Judgment, Anna. May I please, my lord?
Yes.
Lordship, I beg to mention item 45, your lordship. Lordship, I am appearing for respondent 1 to 4 in this matter. Your lordship, I am yet to receive instruction if 3 weeks' time can kindly be granted, your lordship.
Lordship, this case needs an immediate disposal. This is pertaining to for 4 consecutive years. There are more than 100 vacancy posts, but they are not advertising the post in general quota. And they have advertised only big
Backward.
big word quota only.
Okay,
That
now,
also
now what is your,
backlog quota. So
he is seeking 3 weeks time.
yes, Lordship.
What is your submission?
So this may be for the last time, Lordship.
Lordship, in fact, the notice upon the respondent number 5, who is the NSSB.
If you are seeking 3 weeks, it should be 3 weeks only.
Lordship, in fact, in this matter, I'm here to receive instruction. That is why, Lordship.
No, why have you not received instructions?
Lordship, in fact, some verbal instructions is there, but then without a proper document, your lordship, it is in fact very dangerous to.
No, but why proper document is not forthcoming?
Lordship, they say that they will be sending it. It's under preparation, and it will
From
be
where they will be sending?
from the directorate, your lordship.
How far is the direct?
Yes.
Your lordship, yes, the directorate is of course here, your lordship.
So when you seek time as counsel,
Yes, madam.
you have to ensure that you stick by it. You take instructions
Lordship,
and if required, file affidavit in opposition within 3 weeks.
lordship.
Heard Ms. Z. Zimumi, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government counsel, who seeks 3 weeks time for 3 weeks time, who seeks an adjournment for 3 weeks, as he is yet to receive instructions in this regard, in this matter. Considering the submissions, the prayer is allowed. The no further time shall be granted to the petitioner on the plea that it has not, no further time shall be granted to the state respondent
Lordship.
for seeking instructions. The state respondent, if they desire to file affidavit in opposition, shall do so before the next date of listing of the
Lordship.
case.
Lordship.
Let this
It be
case,
given a
no,
specific.
specific. Let this matter be listed after 3 weeks.
I'm deeply obliged, my lord.
Obliged, Lordship.
May I please, your lordship? My lord, I may be allowed to move one urgent unlisted motion. It is in connection with a medical admission case where lordship has passed the order on 14th, granting 2 days time to the state respondents in view of the last date fixed for admission. They have not complied with the order. So I'm compelled to file a contempt petition to the lordship because fortunately in the meantime, we received information that admission has been deferred to 22nd, the last date. But the seat which is allotted, main reserve, that is in the bottom of the list, that is at Korpa, that is in Chhattisgarh. There is no direct flight from here. So from Dimapur to Calcutta, Calcutta to Nagpur, from Nagpur, it's Korpa is 500 kilometers. So in any case, 2 days journey will be required. So unless some urgent decision and directives are issued by this honorable court, there will be a big problem, and then the order passed by this honorable court is likely to be
Okay.
frustrated, Lordship.
Mm,
So I may be allowed to move the contempt petition unlisted
at
up to
two.
the listed
At
motions.
2.
At 2. Lordship,
Or
if
want to
your
move
Lordship pleases, I will just frankly share
after
my
the
feeling,
move.
Lordship.
Okay, after.
If up to the motions,
Okay.
if it is taken up then at 2, Lordship can issue some direction to appear the person at 2. Then only the purpose of the order passed by this honorable court will be achieved.
Okay. You have informed the other side.
Yes, I have informed and served a copy also to Mo Amchen.
Okay.
Learned additional advocate Shokri, she has left for Gauhati with the intention to file a death appeal. That is what I have learned, and I have been informed also. So all these implications, Lordship may examine.
Okay.
Obliged.
May it please, my lord. Item 50 of today's list, my lord. My lord, prayer that same may be listed at 2 o'clock, my lord. Pleadings are over. My lord, I have been removed from my service, my lord.
No.
2000.
Item number
50. I have taken consent from the other side, my lord. The matter could be upgraded at 2 o'clock, my lord. If it pleases, my lord, that is. 50. Pleadings are over otherwise, my lord.
no, why upgradation?
My lord, because my lord, since 2019, I have been removed from my services, my
But-
lord,
but
and without any pay.
Same may be the case with other cases also, which are above your matter in the cause list.
My lord, only if it pleases, my lord.
Okay, we'll see if it is possible or not at 2.
I'm deeply.
Bless Lordship. Lordship, I beg to mention item 44. Lordship, I'm appearing for Bravo Respondent number 5. This IE has been filed by the petitioner, bring for amendment of the bare portion of the petition. Lordship, I filed my objection this morning. So may I be the disciplinary listed tomorrow, either tomorrow or on Thursday, Lordship. Because my objection is not in record, Lordship.
On request of learned counsel for both the sides, let this matter be listed on Thursday. That is on 21st of August.
Obliged.
Please, your lordship, I beg to mention item number 24 to 32, lordship. It's analogous matters, your lordship. If this matter may be listed on Thursday, my lord. Item 24 to 32.
May I please, Lordship? My Lord, I'm mentioning on behalf of LT Sanctum, my Lord. My Lord, I'm informed that he is on leave, so let the matter become after 2 weeks.
Which matter? Item 24 to?
To 32.
In that case, your lordship, let it be on on 8th of September, your lordship.
Lordship, I'll be out of station on 8th of September. I have a matter in Delhi, my lord, before the enforcement directorate. So
11 then.
appellate authority.
11.
11.
Yes.
What is your name?
Esther, your lordship.
Esther. Heard item number 24 to 32. Heard Miss Esther, learned counsel for the petitioners. Also heard Mr. Senti Anger appearing for
Respondents 1, 2, and 3, my lord.
respondent number 1, 2, and 3, as well as Mr. E. Tibafum appearing on behalf of Mr.
LT Sanctum,
LT
additional AG.
Sanctum, learned additional AG. What is your prayer?
Lordship, since he has difficulty on 8th, then let it be on 15th of September, your lordship.
No problem, Your Lord.
On request of learned counsel for both the sides, let this matter be listed on 15th of September.
My lord, deeply obliged. Much obliged.
Lordship, I also beg to mention item number 42, Lordship. Lordship, can it be listed on Thursday for admission hearing, Your Lordship? 42.
Okay. 42.
Yes, Your Lordship.
Heard any objection?
I am for a private respondent. No objection.
Heard Ms. Easter, learned counsel for the petitioner. Also heard Mr. T.B. Zamir appearing for the private respondents, as well as Ms. A. Aimi appearing for the state respondents. Learned counsel for the petitioner has prayed for listing this matter on 21/8/2025, to which the the counsel for respondents do not have any objection. Hence the same is allowed. Hence same is allowed. Let this matter be listed accordingly.
For admission hearing.
Lordship, I have a similar prayer for item number 52 also, Lordship. Hearing item number 52. I've informed the other side also.
I have no objection, Your Honor.
Heard Ms. Easter, learned counsel for the petitioner. Also heard counsel for the other side. Now, learned counsel for the petitioner who seeks an adjournment of this case on the ground of,
Lordship, my senior has personal difficulty today, Your Lordship.
on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is not opposed to by the counsel for the respondents. Hence, same is allowed. Let this let this matter be listed
On Thursday, Your Lordship.
on 21/8/2025.
There is an interim, Lordship.
The interim order shall continue till next day.
Much obliged.
Yeah, Lordship. Lordship, I beg to mention item number 46 and 47. I received the affidavit filed by the government. So let us.
47, 48.
47, 48. Lordship.
47 and
And
48.
48, yes. It's come up on Thursday.
Heard Mr. Muaz Zamir, learned counsel for the petitioner. Also heard Mr. Yangarwati, learned central government counsel,
For the state.
and Ms. S. Mere, appearing for the state respondent. Learned central government counsel has sought for an adjournment on the ground that
Yes, this is my affidavit today. This is my affidavit today only. The affidavit of the government.
he has received the affidavit in opposition filed by the state respondent today only and needs some time to go through the same. The prayer is allowed. Let this matter be listed after,
Let it affix. 21.
not 21. In the next week on a date to be fixed by registry. Let registry fix the date. In the next week on a date to be fixed by registry.
Right. Obliged, Lord.
May it please the Lordship? With the consent from the other side, I beg to mention item number 36. Lordship, I'm praying for 2 weeks' time to file my affidavit in opposition.
What is your name?
YS form.
Heard Miss Y.S. Form, learned government learned counsel for
Respondent number 1 to 5.
respondent number 1 to 5, who seeks some time for filing affidavit in opposition, to which Mr. M. Solo, learned counsel for the petitioner, has no objection. Hence, the prayer is allowed. Let this matter be listed after
2 weeks.
2 weeks.
Obliged.
Your Lordship, I beg to mention item number 41. Your state is yet to file affidavit, so kindly grant me 3 weeks' time, Your Lordship.
Lordship, I have no objections.
Heard Miss A. Aimi, learned government counsel appearing for respondent who seeks 3 weeks' time to file the affidavit in opposition by the respondent sides. Stop. Learned counsel for the petitioner, Mr. Sentianga, has no objection to the said prayer. Hence, same is allowed. Let this matter be listed after 3 weeks.
Please, your lordship. Lordship, I beg to mention item 38. I pray for 3 weeks, your lordship, to file affidavit in opposition.
No objections, my lord.
Heard Mr. M. Long Kumar,
Yes, your lordship.
government counsel, who
3 weeks.
prays for 3 weeks' time for filing affidavit in opposition by the state respondent. Stop. Mr. Sentianga, learned counsel for the petitioner, has no objection to the said prayer. Hence, same is allowed. Let this matter be listed after 3 weeks.
Your lordship, I have a similar prayer for item 43. I have informed,
43, you are for the petitioner.
for the state respondents, your lordship.
Lordship, I'm for the petitioner.
What is your name?
Rebecca.
Heard Mr. M. Long. You are M. Long Kumar?
M. Longkumar, yes.
M.
M, yes.
Lordship,
Mr.
there's an interim prayer.
Heard Mr. M. Long Kumar, who prays for
3 weeks.
3 weeks' time for filing affidavit in opposition. Stop. Also heard Miss Rebecca, who does not oppose the said prayer, hence same is allowed. Let this matter be listed after 3 weeks. Stop.
Lordship, there's an
The
interim prayer.
interim order granted interim order shall continue till the next date.
Oblige, your lordship.
May it please your lordship. Your lordship, I may be allowed to move an urgent unlisted matter motion today.
What is the
Sorry,
matter?
active steps have already been taken by the respondent to forfeit my BG bond of more than 50 lakhs. And if this urgent listing is not allowed, then I think irreparable damage might be caused to me.
At 2.
Yeah.
At 2 p.m.
Yes, sir.
May it please your lordship, I beg to mention item number 11 to 23. Lordship, if this matter can be listed on 2nd of September.
Let it be any date after 9th of September, Lordship. 11 Lordship.
Let the registry fix the date. You choose a week.
Second week.
Second week of September.
My lords, I appear in item number 17, 18, 19, 20, 22, and 23, my lords. My lords, I have filed the reply on behalf of respondent number 7 and 8 in all 6 matters. My lords, that may be recorded.
17, 18,
19,
19,
20,
20,
22, and 23.
22, and 23.
These, my lords.
What
For
is the
respondent number 7 and 8. My lord, Sakshit Bhardwaj. I'll drop the name in the chat box, my lords.
for the petitioners?
And the petitioner.
You give the names, take the names of the parties. Or let me dictate. Heard Mr. C.T. Zamir, learned senior counsel
11 to 16.
appearing for the petitioners in writ petition number 251/2021, right up to 16. Right? Yes, write the numbers of the cases from 11 to 16, C.T. Zamir. Also, Mr. T.B. Zamir appearing for the petitioner in writ petition number, write the name, number of the case from 17 to 23. Also heard Miss, what is your name?
Interim.
You are submitting on behalf of?
Respondent number 4 and 5 in item number 11 and 13.
No, who is for the state respondent?
Lordship, I am for the state.
Heard Mr. N. Angami, learned senior counsel, appearing for the state respondents.
For item 11 to 16, state respondent is 1, 2, and 3. And item 17 to 23, state respondents are respondent 1 to 6.
Okay, I just mentioned state respondents. Yes, who else is appearing?
Your Lordship,
Please, my
I'm-
lords. I'm so sorry.
Your Lordship, I'm for respondent number 4 and 5 in item number 14, 15, and 16.
Also, Miss
Shisa Jamir.
Sisha Zamir, appearing for respondent number 4, 5, and 6.
Respondent number 4 and 5,
4 and 5 in item number
14, 15,
14,
and 16.
15, and 16.
And Lordship, item number 21, I'm for respondent number 7 and 8. Item number 21.
For respondent number 7 and 8 in item number 21.
Lordship.
Also, Mr. S. Bhardwaj, appearing through video conferencing for respondent number 7 and 8 in item number 17, 18, 19. Which is the other
Lords 20, 22, and 23.
20, 22, and 23. He submits that the said respondents have filed their affidavit in opposition today.
No, my lords, it was filed way back on 4th of August.
Has already filed their opposition affidavit in opposition on 4th of August. On request of learned counsel for both sides, let this matter be listed in the second week of September on a date to be fixed by registry.
Highly obliged, my lords.
May I please, Lordship? Lordship, I beg to mention item number 37. Lordship, I have sent for waiting, so kindly grant me some time to file my affidavit.
37,
Lordship,
why are you seeking time?
I have sent for waiting, Lordship.
Okay,
I'm for the petitioner.
heard Miss Bichano, London Government Council, who submits that the affidavit in opposition of the respondents has been sent for vetting, and she therefore seeks for some time for filing the same. Also, Mr. Toshi Temjen call somebody from computer section. Toshi Tenjem Pongener, learned counsel for the petitioner, as well as,
I'm appearing for respondent number 6.
what is your name?
Libo Zukum, Lordship.
Aliba Ozukum, appearing for respondent number 6, who do not have any objection to the prayer made by the learned government council. Hence, same is allowed.
Lordship, in the meantime, I may be allowed to file my reply to the affidavit in opposition filed by respondent 6.
Stop. Learned counsel for the petitioner also seeks leave of this court to file a reply to the affidavit in opposition filed by the state respondents.
Respondent number 6, Lordship.
With respondent number 6, the prayer is allowed. Let this matter be listed after how much time?
2 weeks time.
3 weeks on a date to be fixed by registry.
Much.
Lordship, I also like to back to mention item number 40. Lordship, kindly grant 3 weeks time to file affidavit in reply to the affidavit in reply filed by the petitioner.
Item number 14,
40, Lordship.
40.
Lordship.
Heard Ms. Bichano, London Government Counsel, who seeks 3 weeks time for filing affidavit in opposition by the
To file affidavit in reply, Lordship.
affidavit in reply against the additional affidavit
Lordship.
filed by the, you are for the petitioner.
Yes, Your Lordship.
What is your name?
Sigmo.
Write her name. Learned counsel for the petitioner has no objection to the same. The prayer is allowed. Let this matter be listed after 3 weeks.
I
Yes, Your
oblige,
Lordship.
Lordship.
I may be allowed to make a mention, Lordship, for item number 39.
Yes.
Hearing this matter, Lordship, all the pleadings are completed, so I pray the matter be fixed for hearing.
Heard Mr. What is your name?
Sentilo.
Heard Mr. Senti Long, learned counsel for the petitioner. Also heard Mr. E. Tibafom, learned government counsel appearing for
Respondent number 1 to 4.
respondent number 1 to 4, as well as Mr. Aliba Ozukum
Respondent number 5, Lordship.
appearing for respondent number 5. It is submitted at bar that the pleadings in this case are complete and the matter is ready for hearing. Accordingly, let this matter,
My lord, let the matter become up on 11th of September. Fixed date.
let this matter be listed for hearing on 11th of September.
My lord, there's an interim, so I pray interim.
The
may be-
interim order shall continue till next date.
Much obliged.
May I please, Your Lordship, allow me to mention item number 24. Your Lordship, I'm appearing on behalf of my senior Takakichu for respondent number 4. If 3 weeks time may be allowed to file affidavit in opposition, Your Lordship.
24 has already been mentioned. Item number 24.
For motion, item number 1.
Please, Lordship. Lordship, here the petitioner is aggrieved by the order dated 25/7/2025, arbitrarily and illegally excommunicating the petitioner from the Sanctum community for a period of 15 years, and thereby debarring the petitioner from representing the Sanctum community in any forum, government, non-government department, organization, also debarring from getting any recommendations, NOCs from the village, area, tribe, and tribe. And more ironically,
Where is the impugned order?
Lordship, the impugned order is at page 59, annexure 3.
Who has passed this order?
Lordship, it has been passed by the United Sanctum Likum Punji.
What is
The
it?
apex, it is a NGO, non-governmental organization, but it is the apex tribal body of the petitioner's tribe, Sanctum tribe. The tribe,
Whether it petition lies.
Lordship, as per Article 12 and 13, Lordship, the petition lies, Lordship.
How?
Lordship, since the rights of the fundamental rights of the petitioner has been violated, the petitioner, Lordship may,
But whether this United Sanctum Likum Pumji comes within the definition of state under
Article 12, Lordship,
12, 12
Lordship, 12
and 13. 12 and 13
Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and 13 Lordship, 12 and Lordship may. Lordship,
You have to satisfy that. You have to satisfy me on that.
Lordship, here under Article 12 of the Constitution of India, in this part, unless the context otherwise requires, the state includes the government and Parliament of India and the government and the legislation of each of the states and all local, Lordship, local or other authorities within the territory of India or under the control of the government of India.
What is meant by local authority?
Lordship, local authority, Lordship, here, Lordship, the United Santam Likum Punji. It is a organization of it's a tribal organization, Lordship. It's the apex tribal organization of the petitioner tribe, Sangtam tribe, Lordship. Lordship, may come to page 10, Lordship.
Okay, we are issuing notice, keeping the question of maintainability open.
Lordship, I have a Lordship interim prayer also to stay, Lordship.
Interim after appearance of the respondents.
Lordship, because in a similar matter, Lordship reported in 2019 volume 1.
No, you have to satisfy me how the petitioner comes within the purview of local authorities.
Lordship, since the state of Nagaland, Lordship, here every tribe, the 16 tribes are represented by apex bodies which govern the tribe, Lord. Here the tribe by and remark of the petitioner in a WhatsApp group, the apex body of the tribe, which the petitioner belong, has issued this impugn order excommunicating the petitioner.
That is not my query. My query is how the petitioner comes within the definition of local authority under Article 12 of the Constitution of India. That you have to satisfy.
Lordship.
You are only making a statement that it is a local authority.
Lordship.
Justify how it is local authority. Suppose few people forms a group,
Lordship.
an association, whether that will be regarded as a local authority within the meaning of Article 12. You have to satisfy me. If you satisfy that, your prayer for interim relief may be considered. Otherwise,
Lordship,
if you fail to satisfy, then this writ petition is not maintainable.
Lordship.
It is liable to be dismissed.
Lordship, then let it come up tomorrow, Lordship.
You will come up with answers.
Lordship.
Okay.
Lordship.
Heard. Mr. Foseco Forte, learned counsel for the petitioner. When a specific query was posed by this court as to how the petitioner may be regarded as local authority within inverted comma, within the meaning of Article 12 of the Constitution of India, comma, learned counsel for this petitioner seeks some time to answer the query. The prayer is allowed. Let this matter be listed tomorrow.
Tomorrow, Lordship.
That is on tomorrow's date, 19th of August.
Obliged.
For motion, item number 2.
May please, Lordship. Lordship, I'm here before the Supreme Court for non-payment of my salary. Lordship, I was appointed as a work charge employee. My appointment is at page 16. This is my appointment order. And then, Lordship, the petitioners are appointed by a common order on fixed pay
as work charge labor. And then my simple submission is that since March 2021 till date, my salary has not been paid. And then Lordship, I'm working for more than 32 years. And then
In which department you are working?
I'm working in this under the establishment of this executive engineer PWD Akanadu division. That is under this Nagaland Public Works Department. And Lordship, my service condition has been duly verified by the district verification board. And then the PIMS number and then my code number has been duly recorded in the portal. Thereby that I am the genuine employee, Lordship.
You are still working?
Yes, still working. And then almost completed 32 years.
Albert, please come. Come. Okay.
So my humble submission is very simple that let my backlog error salary be given to me.
Yes, Miss Mary.
Should let notice go at this stage.
Okay. Heard. Mr. What is your name?
Estimjet.
Estimjet. Learned counsel for the petitioner. Also Miss S. Mary. Learned government counsel appearing for
All the respondents.
all the respondents. This writ petition under Article 226 of the Constitution of India has been filed by the petitioners on being aggrieved by non-payment of his salary as well as area salary by the respondents. Let notice be issued. Returnable after
3 weeks.
3 weeks. Since Miss S. Mary has appeared for all the respondents, no formal notice need to be sent to those respondents. However, the learned counsel, however, the petitioner is directed to furnish requisite copies of the writ petition along with the annexures to the learned government counsel for the respondents within
Due course of the
within the course of the day. List accordingly.
Lordship, the following with
Other cases also.
Yes, Lordship.
In item number
3 to 10.
3 to 10 separate orders will be there, similar order.
Deeply Lordship.
For admission, item number 33.
There was an unlisted matter. Item number 30. Yes.
Lordship, by order dated 17/6/2025, the state respondent is instructed to place the final status report of the regularization of the service.
Order dated?
Dated 17/6/2025, Lordship.
Yes, what has happened? Yes, Miss Aimee.
Your Lordship, this is a matter with regard to regularization. And as per OM dated 2015 OM, the petitioner fulfills the criteria. So his case is under consideration. And at the time of filing my affidavit, I have stated that it is under process. So by order dated 17/6, the court had asked for the latest status. And as per the status, his case is before the cabinet for approval, Your Lordship.
Heard. No, how much time?
Your lordship, we don't know where the cabinet will sit, your lordship, so that's the.
But government has to give an assurance that.
Your lordship, with regard to regularization, we cannot give a time-bound assurance, your lordship, because it's a lengthy process now. Since the case is before the cabinet, once the cabinet sits, then his case will be regularized. But we do not know when it will sit. So, your lordship, if a considerable amount of time can be given, maybe 4 months, 5 months.
Why 4 months? For 4 months, cabinets will not sit.
Your lordship, we have no idea when it will sit.
So cabinet is not sitting for 4 months. Then what government is doing?
Your lordship, in other cases, considerable amount of time has been given.
No.
Then your lordship, I
But there
leave it up
has
to
to
you.
be some reasons, valid reasons. From your submission, it appears that cabinet will not sit for 4 months.
Your
And
lordship,
then how the government is functioning if it is not sitting for 4 months? Heard, Mr.
H. Makam, lordship.
H. Mukam, Learned Counsel for the petitioner. Also Ms. A. Aimi, Learned Government Counsel, who submits that by order dated 17/6/2025, this court has directed the state respondent to inform this court regarding the status of the process of regularization of service of the petitioner. Stop. And accordingly, she submits that as the petitioner conforms to the criteria of Office Memorandum of the year 2015, his case for regularization is under the consideration of the state respondents. She submits that the matter is presently pending for approval of the cabinet, and she seeks 4 months' time for informing this court regarding the decision taken by the cabinet in this regard. You have anything to say? 4 months?
No.
No objection. Learned counsel for the petitioner does not opposes the prayer made by learned government counsel. Hence, the prayer is allowed. Let this matter be listed after 4 months.
Much obliged, your lordship.
Oblige.
For admission, item number 34.
One line, एक line on, add one line. The letter dated 24/6/2025 submitted by Learned Government Council indicating the status of the process of regularization of the petitioner be kept in the record as a part of it. List accordingly. Yes, item number
34. May I please, Lordship, in the last occasion, I have placed one order, that is order dated 14 July 2025. My lord, by this letter, the case has been disposed by the Deputy Commissioner, my lord. So basing on this letter, the matter may be closed, my lord. That is my humble submission.
Where is that letter?
Lordship. Lordship, the prayer of the petitioner was that to dispose of the dispute which the petitioner has written to the Deputy Commission Dimapur that to resolve this land dispute between the petitioner and the respondent of number 4, Lordship. And accordingly, Lordship, the DC Dimapur, by order dated 14 July 2025, has passed this order and matter has been resolved. So in view of that, this petition may be closed, Lordship.
Okay, heard Mr. Foseko Forte,
Lordship.
Learned Counsel.
Yes, Your Lordship, since the matter has been disposed of, it may be closed as such, but if the parties are agreed, if any party is agreed, they will be at liberty to take recourse to appropriate courts. That order may be passed, Your Lordship.
No, that.
Lordship is for a
Since the prayer in the petition is for disposal of the pending matter before the
No,
Deputy Commissioner.
No,
So
now the petitioner does not have any grievance. His grievance has been redressed.
Yes, yes. Now in my.
So his case, this is his petition.
Yes,
You are respondent.
yes. So
If you are aggrieved, there is
Yes.
always
Yes,
such observation is not required
yes, but if.
because we are only disposing of the petitioner's case.
Your
if-
Lordship, then in that case, the order may be simple that by order so and so which is placed before this court, that it has been disposed of, the matter stands closed. Your Lordship.
Yes.
That's all, Your Lordship. Without-
Not Mr. Foseko Forte, Learned Counsel for the petitioner. This is item number.
34.
Also, Mr. E. Tibafom, Learned Government Counsel, appearing for the state respondent, as well as
1 to 4.
state respondent number 1 to 4, as well as Mr. T. Ponganer, Learned Counsel, appearing for respondent number 5. Learned Counsel for the petitioner as well as Learned Government Counsel submits that. No, not this. Learned Counsel for the petitioner submits that as the grievance of the petitioner has been redressed by the Deputy Commissioner by its order dated 14 July 2025. The petitioner does not have any grievance and does not have any grievance, and the writ petition has become infructuous. Accordingly, this case is disposed of on becoming infructuous. Let the copy of order dated 14 July 2025 passed by the Deputy Commissioner Dimapur, Nagaland, be kept in the record of this case as a part of it.
Lordship.
Much obliged.
Right, fellow.
For admission, item number 35.
May I please, your Lordship?
Yes.
Lordship, I'm for private respondent number 4, Lordship. Lordship, I'm yet to file my affidavit in opposition. Kindly allow me some time to file, Lordship. I have the consent from the other side.
Heard Mr. James
James Newman.
Newman, Learned Counsel for
Respondent number 4.
respondent number 4, who seeks some time for filing affidavit in opposition. Also, Miss, what is your name?
Kimpiana.
Kim Piani, PNU, Learned Counsel for the
Petitioner.
petitioner, as well as Miss A. Aimi, Learned Government Counsel, appearing for the state respondents, who do not have any objection to the prayer made by Learned Counsel for respondent number 4. Hence, same is allowed. Let this matter be listed after
Tables.
3 weeks.
Much. For unlisted motion, item number 53.
Your Lordship, before my learned senior friend say regarding the contempt petition, I'd like to apprise your Lordship. I'm standing here as the officer of the court. Contempt petition notice has to go. And I have to file the Vaglatnama because as your Lordship is well aware, contempt petition is an individual capacity. That is one. And your Lordship, I am to inform you that state has referred an appeal. And the principal said, our additional advocate general is waiting. We have filed the filing procedure, we have already completed, and our additional advocate general is waiting for the unlisted motion today.
No, but till that any order is passed by
Appellate court,
you have to comply with the
Yes.
order. If it is stayed by the appellate court, then you may have something to say. But
Yes.
as is,
Yes.
when this 2 days time expire, it is expired. It has already expired yesterday.
That is, your Lordship, I appreciate, I acknowledge the findings of your Lordship. But you see, in this case, I was also one of the counsel for the state. And judgment in order was pronounced on 14/8/2025 by your Lordship.
Yes.
It was posted. CTG copy could happen of 10 just before 4. So now, in the process, office working hour is in Nagaland 10 to 4, 10 a.m. to 4 p.m. So 14 is gone. 14 August is gone. 15 August is, your Lordship is well our Independence Day. 16 Saturday, your Lordship is well aware it's a birthday of Lord Krishna, that is Janmashtami. And yesterday, 17 was Sunday. So
no.
That is the position, your Lordship. And on non-working day, on Independence Day, office cannot function.
That means you want to say that the order has not been complied with.
Owing to the holidays, owing to the national holidays. National holidays office is closed. 14 was national holiday, 15. 16 Saturday was Lord Krishna birthday holiday. Yesterday, Sunday. Today, Monday. So even if we have to comply within 2 days, days become impossible because I think the days that has to be counted is to be working days. I don't know, but
okay, if it is working day, that means you want to submit that you will.
No, I'm just submitting as an officer of this court.
Therefore, I am giving importance to what you are submitting. You will comply with the order by tomorrow.
I'm not authorized by the respondents here in this contempt petition
My lord,
to appear on their behalf
sorry
also.
for the interruption. My learned friend's
No,
submission, initially, he was saying that I am not authorized. If there is no authorization, what is the point to make so many submissions in absence of any authorization?
No,
And whose authority he is submitting? Let him be clear first. Thereafter,
What I'm submitting is as an officer of this court. As an officer of this court, in the common panel. I'm just saying that
What is your submission?
if I'm authorized, I'll appear. But so long as I'm not authorized,
You
I
are
cannot,
the
I cannot argue the
you are the
contempt.
counsel
I was the counsel in the proceeding.
in the
That means 134 and 138. I was also one of the counsel from the government side, state side.
Okay, let us hear.
Lordship, straight to the point, Lordship is well aware about the judgment, but judgment starts from page 13 of the contempt petition. But then I will straight away take your Lordship's attention to paragraph 55 at page 36. This had 4 paragraphs I may be allowed to read because paragraphs are very short so that all of us are again reminded of what direction and order has been passed by this Honorable Court, Lordship. Starting from paragraph 55 at page 36, Lordship. Accordingly, the respondent number 3 is hereby directed. Respondent number 3 is the director of the department. Respondent number 3 is hereby directed to issue a modified merit list of candidates for selection and nomination against central pool of MBBS seats for the state of Nagaland for academic year 2025-2026, including the name of the petitioner therein at appropriate position in the seat list and offer a seat of MBBS course under central pool for the state of Nagaland for the academic year 2025-2026. As it was informed to this court by the learned Additional Advocate General Nagaland during the course of the hearing that only one seat has been kept vacant in pursuance to this court's order dated 28/7/2025, and other 41 seats have already been allocated to other eligible candidates on the basis of merit, and they have been directed to proceed to take admission in the respective allocated medical colleges. Hence, the respondent number 3 is hereby directed to allocate the available vacant MBBS seat under the central pool for the state of Nagaland to the petitioner. Since the last date of admission has been notified to be 18th of August 2025, that is today, the respondent number 3 shall do the needful in this regard within 2 days from the date of this order, so as to enable the petitioner.
Who is respondent number 3?
Number 3 is the director of the technical education, Lordship. Within 2 days from the date of this order, so as to enable the petitioner to take admission in the medical college allocated to her within the time prescribed. 57. The learned Additional Advocate General Nagaland shall inform the respondents about this judgment so that they may comply with the same within the prescribed time. 58. The respondent authorities are directed to comply with this judgment and order in a time-bound manner so that the reliefs granted to the petitioner herein do not become infructuous. The directions are very, very clear, which has been passed by your Lordship. And on 14/8/2025, judgment was uploaded sometime immediately after 2 p.m. Therefore, we have forwarded, and that at 3 p.m. on 14th of August, the petitioner, along with her father, went to the office of the technical education and submitted. Office was open that time. And the father of the petitioner has been waiting for the director till 6 p.m. in the office. But additional director was there, but director was not there. And later on, it was informed that the director is not coming. They are very much aware about the judgment. Even now also the counsel for the respondents has considered before the Honorable Court that around 4 p.m. only they have received the judgment. Admittedly, they have received the judgment. I have enclosed a copy of the petition application which I have submitted, enclosing a copy of the judgment also on 14th of August. And requested them to, considering the time-bound manner, this may be done. Nothing was done. 2 days expired on 16/8/2025. Now, till date, they have not done. If at all they have good intention to comply with the order passed by this Honorable Court, there is a way out. I cannot stop them filing the writ appeal, and for that matter, nobody can stop them filing a writ appeal. Even if it goes against me also, I may have the right to do the same thing. But as Lordship has correctly pointed out that the implication of Order 41, Rule 5 of CPC will come. mere filing of appeal is not enough. Unless there is a stay order passed by the appellate court. As of now, there is no order. By that time, the 2 days granted by this honorable court has already been lapsed. This very fact shows that they have no intention to honor and comply with the judgment of this honorable court. Now, today is the first day after 14th. Let us say, has they filed any application before this honorable court, informing this honorable court their intention that, look, due to time constraint, we could not take any steps, but we have filed a writ appeal and we have every intention to do this like. Now also there is possibility for the department that fortunately on 14th evening, afternoon, the time of last date for admission, which was earlier fixed on 18, has been uploaded in the website and it is extended to 22nd Lordship, 22 August 2025. That is just a coincidence. Had there been no extension of this last date of admission, by now, the relief granted by this court may have become infructuous and meaningless. Can the order of the court be just thrown to a dustbin without complying to the direction
Yes,
by this honorable court?
Mr.
Lord Chief is well aware about the appearance of so many prime ministers of the country in the dishazarik court in Delhi also.
Well, now, what is your submission?
My submission is they have already committed contempt for non-compliance of this honorable court's order. So the director of the department should be punished in accordance with law, number one. Number two, I do not get pleasure in putting somebody to civil prison or whatever. I don't get pleasure in punishing somebody. But my submission is the order passed by this honorable court has to be complied with, big or small, rich or poor, high or low, mighty or low. The rule of law has to be maintained. Nobody is above the law. What is the meaning of passing the orders by this honorable court? To be complied with, to maintain the rule of law. Nobody can defy this. And if anybody defy the law, then they should get appropriate punishment for compliance of the order passed by the honorable court. Even the chief minister, who is the head of the government, he swear under the constitution and assume office. Nobody is above the law. And they have sworn under the constitution to abide by law of the land.
Lordship, I'm standing here as a counsel of the writ petition.
Conditional admission can also be taken.
138.
Admission may be subject to the final outcome of the writ appeal. If at all, that can also be done.
What?
Admission can be done. Conditional admission in the sense that if they succeed in the writ appeal, the admission taken will be at the risk of the petitioner. And if they succeed in the writ appeal.
No, we do not know about the filing of the writ appeal
Yes.
or what has.
As of now, it is just
Now
a
in this
submission.
As the
context,
officer of this court and the
In
government panel,
this contempt petition-
I am just informing before your lordship that the happenings right now. And so far as the contempt petition has been concerned, which has been filed by my learned senior friend, I'm not coming to that merit, but I'm just apprising you before your lordship the circumstance of what has been happened.
no, Mr. Imchen, you are senior government advocate representing the state respondents.
Yes.
I responded.
2 days time was given, specific time frame was given to the respondents authority to comply with for whatsoever reason, if they are unable to comply with the order, they should have informed this court
Correct,
today itself
correct.
that for these reasons we are issuing notice. The respondents have to appear in person at 2 p.m. today.
Your lordship, I've explained before your lordship.
You inform them.
Lordship, I have explained before your lordship in the very beginning. 14, we got the CDC certified to true copy only at 4. And 15 was holiday, 16 was holiday, 17 was Sunday. So by common sense,
What prevented you from informing this court? Otherwise, you need not to have even filed writ appeal if the relief itself become infructuous. By lapse of time, if by
Going by the submission of by Leonard Fred, 4 p.m. is the last working day. They are filing writ appeal this morning. That is what I have been informed. They have been working during the holidays. Otherwise, they could not have filed the writ appeal this morning. All were holidays. But for the purpose of filing the preparation of the writ appeal, they are working. And to comply with the order passed by this honorable court, they are sleeping. And they are
Your Lordship, we were working in the lawyer's office.
No, you
not in the government office.
You asked both the respondents to appear in person today at 2 p.m. Will it be possible at 2? I can give extension for few hours, but today itself they
Because,
have to.
as I said before, your Lordship, I'm not authorized.
No,
by the
being officer of the court.
Yes.
Being
It is just to inform the.
You inform I'm passing orders also. The registry will also inform. And you have to also inform to appear, to ask both the contemners to appear in person.
Lordship, if they ask me to appear, then let me find out and on their behalf, let me appear at 2.
No, they have to appear in person.
Because I've explained the situation, your Lordship, very
No,
clearly.
let them
There was no working day.
Let them explain. What prevented them?
Lawyer's office is no timing. We work only on Sundays.
Mr. Imchen, when this court passed order granting you 2 days time, it was aware that the following days were holidays. Still only 2 days were granted knowingly because of the deadline. The deadline was Monday. It is not that the court passed order without knowing that the days following the date of passing of orders were holidays. This was known to the court. And this was known to you also when the order was delivered in the open court. None of the government counsel raised this plea that it was holiday, therefore some extensions may be granted. This plea was not taken then. The judgment was delivered in the open courts. If by this way court's orders are not followed.
Your Lordship, judgment was, we have heard on 11, judgment was reserved and it was pronounced. It was pronounced.
Yes, it was pronounced. The operative part was read over.
Lordship.
At 10:30 on 14th. And there is a specific direction to the additional advocate.
Ask both the contemners to appear in person. If they fail to give proper reply, and if you do not get relief from the appellate court, they may have to face consequences.
Your Lordship, notice be issued, and let this matter will come up tomorrow.
No, the deadline was.
Because Your Lordship, I've explained that working days, 2 days. 14 was Independence Day, 16 was holiday, 17 was Sunday. Lawyers of office do we work. But common office is it?
The time has been extended.
Yes, but Lordship may consider one aspect. The place is Korpa, that is in Chhattisgarh. There is no direct flight. So if I get ticket tomorrow, then I have to fly to Calcutta. Thereafter from Calcutta to Nagpur, it takes 11 hours travel journey time because everything is connecting flight has to be. From Nagpur, it's 500 kilometers to reach Korpa by road. I have to go by road and see the situation. At night, I cannot travel in Chhattisgarh. Lordship is well aware. What is the situation in Chhattisgarh? Naxalites and all these problems are there. So they are deliberately delaying day after day.
No, Mr. Zamir. Now we are in this contempt petition, we are exercising contempt jurisdiction.
Lordship.
If they don't comply, they will have to face consequence.
Lordship, yes. I have two options, Lordship. If my learned friend declines, even to inform to his client, because he was representing the director and the secretary. And if he declined to accept, to inform them about the order passed by this court.
No, that cannot
Then
be done.
registry may be directed to depute the special messenger to deliver the notice to the director and the secretary.
He
That
cannot
is possible.
decline.
So as to comply with the order.
No, whether an officer of the court can decline
No,
comply with the order.
because Lordship is well aware, contempt is a different issue. I have to be authorized. I have to file my Bhagatnama to appear. I have to be authorized. I have to be, because contempt is an individual capacity. I have to be authorized by the officer concerned. And I have to file my Bhagatnama.
My learned friend is making submission on merit and to pass on information to the concerned party. Learned friend is reluctant to do that. What is this? In the name of an officer of the court, my learned friend is making submission. So the same principle can be applied as an officer of the court to inform to the concerned officer. You make submissions, whatever you feel like in the name of the officer of the court. And now you don't want to take the responsibility as an officer of the court. That too a direction by this honorable court.
Heard, Mr. Seat is Amid, learned counsel for the petitioners. Also heard Mr. Moaim Chen, learned senior government counsel, who submits that as he was counsel for the respondents in the writ petition, he is appearing before the court. However, he has not yet been authorized by the contemners to appear on their behalf in this contempt petition. Stop. Next paragraph. This application under Section 12 of the Contempt of Court Act 1971 has been filed by the petitioner, Ms. Vatsala Pangal, alleging willful and deliberate violation by the contemners of the order passed by this court, of the judgment and order passed by this court on 14/8/2025 in connection with writ petition number 134/2024 as well as writ petition number 138/2024. Stop. Learned counsel for the petitioner has submitted that this court in the aforesaid judgment has had categorically directed the respondent number 3 within bracket contemner number 2 in this contempt petition bracket close to comply with the directions given in paragraph number 55 and 56 of the aforesaid judgment within 2 days of the date of the said judgment. He also submits that in paragraph number 58, this court of the aforesaid judgment, this court directed the respondent's authorities to comply with the judgment and order aforesaid judgment and order in a time-bound manner, so that relief granted to the petitioner do not become infructuous. Stop. Learned counsel for the petitioner, learned senior counsel for the petitioner, however, submits that the petitioners, in order to frustrate the relief granted to the contemners, in order to frustrate the relief granted to the petitioner, have willfully and deliberately violated the order of this court, and therefore they are liable to be punished accordingly. On the other hand, Mr. Moim Chen, learned senior government counsel, has submitted that he is appearing before this court as an officer of the court, and he has been informed that the state respondents have preferred an writ appeal before the principal seat against the aforesaid judgment. Stop. However, he is unaware as of now as to whether any stay has been granted in this writ appeal, which might have been filed by the state respondents. Stop. He also submits that as of now, he has not yet been authorized by the contemners to appear on their behalf in this contempt case. Stop. I have considered the submissions made by learned counsel for both sides. Prima facie, it appears that there is a deliberate non-compliance of this court's order, as even after lapse of the time granted to the respondent authorities, this court, respondent authorities, there is nothing on the record to show that either that the directions given in the aforesaid judgment has been complied with, or that the said judgment has been stayed by the appellate court. Considering the gravity of the though Mr. Moam Chen, learned senior government counsel, tried to justify the non-compliance of this order, court's order, by the contemner. However, this court is not satisfied with the justification so given. Hence, the registry hence both the contemners are directed to appear in person before this court today. At what time you will?
It's going to be 12 now, your lordship, see.
You suggest time. They are in Kohima only.
I don't know that, I cannot comment whether they are in Kohima or.
Okay, you find out.
Then the additional advocate general is also present, lordship.
Yes, Mr. Imsong. At what time?
Lordship,
I'm just asking you, putting this query to you as regarding you to be an officer of the court. What were?
with due permission of the honorable court, considering the facts and circumstances on the part of the petitioner also.
No, these things, these clarification have already been given by the learned senior government counsel.
Your lordship, I will be allowed to one keep a submission that fact. Because the appeal has referred before the principal bench, but it will come on unlisted. And you see the principal bench workload is such, so it will come on relaunch only. So if it is, your lordship, considering all the facts and to avoid any complication in the future. So my humble submission before lordship, if it is waited till tomorrow.
No,
So
no,
that
no.
we can take the order.
Appeal will be moved unlisted today.
Yes.
So likelihood that whatever order the appellate court will be passing, it will be passing before
Your lordship, we cannot say that in the principal bench.
at
So,
3:30 you appear.
My humble submission, if it is deferred to tomorrow.
No,
With
no,
the
no.
discussion of tribunal court.
No.
Because appeal is.
Both the contemners shall have to appear today at 3:30. Otherwise, they will have to face consequence. What is the last line?
Yeah, that is my humble submission.
At 3:30 PM. Learned additional AG Mr. Imting Song, who also is present in the court, is requested to communicate orally regarding the order passed by this court and asks the contemners who are officers posted in high position in the state government, to appear before this court in person as directed. In the meanwhile, the petitioner shall also take steps for issuance of notice upon the contemners. The said notice shall be served on the contemner by the registry by sending special messenger today itself.
Lordship, this order may be communicated at the earliest, so direction may be given to the.
A copy of order may be furnished to the learned to Mr. Imti Song, learned additional AG, immediately. At 3, release this matter again at 3:30 today.
Meantime, lordship may also consider the consequences of order 41.5.
Yes, if in the meanwhile stay comes, then okay. Otherwise,
Sufficient opportunity has been given to them.
we'll wait till Abhishek change kar lo. Okay.
For hearing item number 46.
Who is for the petitioner? You're ready?
I'm ready, Ma'am.
You're ready?
Yes, my lord.
Okay.
In fact, the matter was heard at length on the earlier occasion.
I have heard it.
Yes, my lord. It's part heard.
Okay.
My lord, in a way, I've concluded my.
Then we should
Submission.
finish it today. If it is still part heard.
Yes, my lord. It is left part heard.
Item number?
46. 46.
Yes, you have to refresh. Any written submission was given? No. What is the matter? I have forgotten everything.
If my lord so requires, then I can give my resubmission in detail, my lord, by taking my lord to all the documents.
No,
that
you refresh the memory. I
My lord, this-
have taken notes.
My lord, this matter pertains to non-payment of compensation, damages compensation to the petitioner by the NHITCL for the damage caused beyond the ROW. My lord, in order to while constructing the national highway from Dimapur to Kohima, a portion of my land was acquired. And compensation in that regard has been paid. And I have no grievances in that regard. Compensation in respect of ROW acquired was already been paid. I have no grievance in that. However, while constructing the road, damages has been caused to
What damages?
building. There's a 3-story building that was on the verge of completion, and because of the reason that the NHITCL, despite having been informed that without a protection wall being built to protect my property, no action has been taken. I have written several correspondence right from 2017 onwards. May I take your lordship to page 22, annexure A of my petition.
Yes.
This is the first petition. This is the first application that I've communicated my grievances to the SDO civil. Because at this point of time, lordship, the approach road through which I transport building materials to my new under construction building has been cut off, and therefore the first application is made in that regard. This is dated 11 January 2017. As early as 11 January 2017, I have been communicating. Again, lordship, may kindly see page 23, next page. This is dated 2nd of April 2018. Again, since no action has been taken by the NHITCL nor the government, state government, I have written again to Deputy Commissioner. Earlier, I have written to SDO Civil, Zubza, because the land in question is situated at Serra Colony, Zubza, under Kohima district. I continue, Lordship.
Yes, the 4-lane goes through your land.
The 4-lane goes through my land. It's
Therefore, your land was acquired.
yes, Lordship.
Compensation was given against that.
Lordship.
Now you're saying that during construction of road, due to plying of vehicles and for other reasons, some property which has not been used for construction of road, which belongs to you, has been damaged.
My lord, I'll come to that point, my lord. Initially, while the construction firstly took place, only the approach road to my properties has been damaged initially.
Approach road only.
Yes.
Okay.
And then slowly, since no action has been taken by the constructing authorities, landslide has started occurring, and then my property has slowly been damaged, Lordship. And Lordship, the important document.
Just a minute, Albert, from that side. So we should to type it out and with that drop for the here itself. Okay. With a free value and also the register. Now from back side with issue number. Yes.
So Lordship, on page 23, I've written to Deputy Commissioner again. And in page 24, Lordship, this document is very important. This is a correspondence to the Deputy Commissioner from the Subdivision of Officer Civil Sector Zubza. Lordship, may I read?
Yes.
Subject to Deputy Commissioner Kohima, Nagaland, subject to verification report on the damages caused due to 4-lane works at GREF camp area, Setsa Zubza. Sir, in inviting a reference to the above cited subject as directed by your authority, the verification was carried out on 15 April 2018 in presence of the affected landowners, Sri Thejao Sekose, that is the petitioner, Lordship, and the head DB Setsa Zubza. It may be mentioned that the height of the earth cutting for the highway in some portion of are as high as 40 to 50 feet approximately. Because of the extensive nature of earth cutting for the highway, farmhouses and paddy fields belonging to Sri Thejao Sekose on the hillside is being affected by way of cracks and land upheavals, developing almost the entire stretch of his land. The extent of cracks in some cases being more than 500 to 600 feet away from the ROW. Properties affected, Piggery, number 2, under construction RCC building on the verge of completion, under bracket. 3, terrace field damaged by cracks and upheavals, thereby rendering it unfit for cultivation. Immediate threat. There are 2 HT towers falling within the land of Sri Thejao Sekose. In one of the HT towers, the base is already affected by cracks and upheavals, thereby posing grave danger to human lives. The other HT tower is just next to the household inhabited by a family. The landowner as well as the undersigned had advised the family to vacate and shift to a safer location as a precaution. Suggestion: the Department of Power be directed to visit and take safety measures at the earliest for the HT towers. 2, the NHIDCL contracting firm may be directed to construct breastwall covering the entire height and along the entire stretch at the earliest in order to arrest further damages.
Yes.
And my lord will find at the bottom enclosed photographs. Photograph was taken by the administration authorities. In page 25, the photographs where damage has been caused to the my cultivated land, the damaged paddy fields, upheavals and subsidence has been caused, rendering it unfit for cultivation, Lordship. In page 26, Lordship will find that This is the earth cutting. After the box cutting, after this earth cutting has been carried out, the height of the earth cutting is approximately as per the verification of the civil SDO, it's about 40 to 50 feet. And therefore, in the suggestion also, because of this reason, unless a breastwork covering the height is being built in order to protect the land, then further damages is going to be caused. In page 27 also, Lordship will find that land erosion in my private land due to falling into construction, some photographs can be found. And Lordship, this very late correspondence from SDO Civil to Deputy Commissioner, this is dated 15th of April 2018.
At which
Again, may I take your Lordship to annexure E, page 34.
So that whenever you pass after something, you say you have to communicate it to it within the private special session information. Considering the urgency I call. Okay.
Which
Yes,
for
sorry.
annexure E series, Lordship.
Yes.
This is a letter from Deputy Commissioner written to the General Manager NHIDCL. This is a forwarding of the list of complainants regarding compensation sought due to falling under Kohima district. May I read the content, Lordship? Now, with reference to the above cited subject, I have the honor to forward here with the list of complainants regarding compensation sought due to falling under Kohima district. The list enclosed is prepared after field verification and found genuine. Therefore, is forwarded to your perusal for further necessary action. Deputy Commissioner. And in the next case,
How much damage has been caused to you? Have you quantified?
Yes, Lordship.
Where?
Lordship, during the pendency of this matter, the behest of the NHIPCL, the respondent number 1, 2, and 3, they have written to the Deputy Commissioner to conduct a joint verification 2 times. And I have annexed those documents also, Lordship. And pursuant to those requests, a spot verification has taken place wherein the NHIPCL, the line departments, and the petitioner, we all participated. And after the verification is done, the line departments, they have submitted their assessment report to the Deputy Commissioner, which was then again forwarded to the NHIPCL.
Where is that assessment?
Lordship, possible to find this in my actually that is in the plan. In this regard, the state government has also filed one affidavit, Lordship. However, in my affidavit in reply, as your Lordship read it.
Okay. Yes.
Lordship, can you see page 10, annexure 1?
Yes.
Now, this is the letter from the NHIPCL to the Deputy Commissioner requesting for a joint verification, Lordship.
Joint verification for what purpose? To
Married the document.
assess the damage.
Lordship, I'll just read out the document.
Yes.
To the Deputy Commissioner, Kohima District. Subject 4-laning of Kohima, Dimapur Kohima Road from design KM so and so to kilometer so and so, existing KM so and so to KM so and so, excluding Dimapur and Kohima bypass in the state of Nagaland under SARDP NE through an engineering procuring and construction EPC contract package 3 matter regarding damages and losses at Sera Colony near Grief Camp, Setsazubza under Kohima district. And then reference number has been given. Sir, with reference to the above cited subject, the letter under reference above, it is requested to provide the details of this disbursement of compensation amount, area of land acquired from Sri Thejao Sekose for information to this office. Number 2. Further, it is also requested to notify a convenient date, that is from 11th to 14th June 2022, for joint site visit to identify the damage and losses of Sri Thejao Sekose at Sera Colony, Setsazubza for resolving the issue at the earliest. Number 3, the cooperation of the district administration in this regard is highly solicited on the subject. This was written by General Manager, NHIPCL, PMU, Dimapur.
Okay.
The second letter, Lordship will find in page 12, annexure 2.
Yes.
May I just read the content, Lordship?
Yes.
From the Deputy Commissioner to, from NHIPCL General Manager to Deputy Commissioner. Sir, this has reference to the above cited subject and letter under reference 3 above, which this office has requested to notify a convenient date for joint site visit to identify the damage and losses of Sri Thejao Sekose at Sera Colony, Setsazubza for resolving the issue at the earliest. However, it is observed that the same is still awaited. Number 2, in addition, it is to inform that this office is in receipt of a petition number WPC so and so, the present writ petition, which has been filed by Sri Thejao Sekose. In this regard, it is requested to kindly inform this office regarding the genuineness of the cited writ petition and notify a convenient date for joint site visit at the earliest. After this, Lordship, a joint verification has taken place. And in page 14, annexure 3.
Where is the assessment?
Assessment, Lordship will find the assessment in annexure 5, page 70.
Okay.
Lordship, this is the assessment submitted by Executive Engineer PWD Housing Central Division.
This is with regard to the damages caused.
Damage caused to my building, Lordship. I have constructed one RCC building, 3-story building, which has 10 rooms. And damage has been caused to this building.
Quantum of 99 lakhs 60
Lordship
9,000 is
this is
only with regard to your damage suffered by you.
Yes.
Or
only with regard to the building. This is this assessment.
Okay.
And then, Lordship, besides this assessment, the Forest Department also made certain assessment. Lordship will find in page 20. The assessment submitted by the divisional forest officer to the deputy commissioner.
Yes.
Lordship, the assessment, this assessment
Of the trees,
Lordship will find
trees
in
and
page 20.
plantation.
Yes,
So 13,93,000.
Lordship.
This is in addition to what has been assessed
Yes,
due to
Lordship.
building
Lordship.
damage. Okay.
Lordship, and then in page 26, annexure 7.
Yes.
The revenue officer, Kohima, has communicated this assessment to the general manager NHIDCL.
Okay.
And after this assessment was communicated to the NHIDCL, the respondent 1, 2, and 3, these respondents, they have come before this honorable court objecting in the form of an affidavit again, challenging or objecting the assessment, Lordship.
Okay. This annexure 7.
Lordship, there's an additional affidavit filed on behalf of respondent 1, 2, and 3.
Additional affidavit.
Yes. Filed on 4th 9, 2024.
Yes. Yes.
Yes, Lordship, by this affidavit, they have raised certain grounds. And your Lordship will find these grounds in paragraph 4 of the affidavit.
Yes.
Lordship will, somewhere in the middle, Lordship will find the word firstly involved.
Yes.
Yes. Narrate, Lordship.
Yes.
Firstly, the said report nowhere indicates the cause of damage. Secondly, it does not give the specific demarcation of the ROW by indicating where it begins, ends, since for this 4-lane highway, ROW is ordinarily obtained for 45 meters, where on 24 meters of the ROW, the road has been constructed. Thirdly, it will be completely incorrect to accept the forest plantation damages assessment conducted in 2024 for earth cutting of the road executed in 2017. Fourthly, the said report does not state that the EPC contractor MS Gauhati project is at fault for damage caused, and is it due to natural calamities? Fifthly, since there is a dispute as to whether damage was actually caused by the respondent number 1, 2, and 3, and or EPC contractor, the same needs to be settled by taking proper evidence as mandated under the law, such as the Indian Evidence Act, Civil Procedure Code, and other ancillary laws. The same cannot be settled by a writ court by exchanging affidavits before this honorable court under Article 226 of the Constitution of India. Sixthly, the petitioner has not established the fact that he had taken all due care and caution in order to ensure that his building shall not be damaged by landslide, that but for the construction of the four-laning highway by adopting wrong methodology by the contractor, his property could not have been damaged. This is the response of the NHIDCL after assessment has been submitted to them.
Okay.
Now, Lordship, at their behest, the verification has been conducted. NHIDCL, they very much participated in the during the time of verification. There was an engineer present, and he was in fact leading the entire verification process. I have annexed one photograph for your.
But they can challenge the finding of that verification process if it is done by some other authority. Who verified? Which authority gave report after that?
Assessment was not was done by the state.
Okay.
Lordship, the state will be in the position to answer your Lordship in that regard, Lordship. However, after all this verification has been done, now they are taking a U-turn and challenging by raising those questions, Lordship. Before the construction of this four-lane road, Lordship, there was no history of landslide, or for that matter, earthquake, or any other natural calamities. Only because of the reason that this construction has taken place and because of the reason that the constructing authority has not taken due care by constructing protection wall, Lordship. Slowly and gradually, landslide has taken place. Subsidence has caused to my cultivated land. My piggery has been affected, which is a source of livelihood for me. And then my residence, which was constructed with my hard-earned money, was affected. Until this day, I have no access to my properties, Lordship.
What is the status now?
Status now, Lordship, it was left uncultivated because it's unfit for cultivation, and the building was left as it is because I could not construct, I could not complete the building, and cracks have developed in the building. Therefore, it's not safe for human inhabitation, Lordship.
Yes.
Lordship, I'd be allowed to place some photographs for just to visually aid this honorable court. Lordship, these are photographs that were taken from the globally accessible Google Earth, and the years are indicated in the photographs, Lordship.
Just a minute. You have your seat. Yes. Yes, sorry. You may continue.
Lordship, these photographs that I'm placing before this noble court.
What it indicates?
Lordship, Lordship may see from the last photo, starting from the last photo. Not from the
Photograph number?
photograph number, the last number, Lordship may kindly see them. At the bottom, at the bottom.
You have numbered the photographs.
I've numbered the photos. So starting from number 1, Lordship.
You say the number, I will see that. Yes, number 1.
Number 1, Lordship, this is only for illustrative purpose of how damages has been caused
Yes, yes.
to my
What
property
it
over the
indicates.
years. Lordship will find that in the photographs, the year is being indicated, it's time stamped. 2006. 2006,
Okay.
Lordship will find at the top, left top. So
Yes.
this is my petty Lordship. And at this point of time, in 2006, no construction activities has
Which
taken
one
place.
is your land?
Lordship, Lordship Nekain,
There is only indication of your grocery shop. You are Sekoshe.
Lordship, the cultivated land, cultivated portion of land in the middle. Lordship, the paddy cultivation,
Yes.
which is in the middle, Lordship. The entire proportion, this entire portion is my land, Lordship.
Okay.
So in 2006, this is the condition. And the next photograph, 2010. It's more or less the same. At this point, construction activities has not taken place, Lordship. And then the next photograph, photograph number 3, 2012. Has your Lordship got it?
Yes.
2012.
Yes.
So the entire middle portion is the cultivated land, and from somewhere near the grocery shop, an approach road is being constructed till the cultivated land. Lordship will notice there's a small stretch.
Yes.
And Lordship may kindly see the next photograph, which is of 2014.
Yes.
Even at this point, construction of the road has not taken place. However, Lordship will find somewhere in the middle that some constructional activities instead of the paddy has somewhere in the middle of the paddy field has taken place. Lordship here.
Okay, okay.
Yes. And serial number 5, photograph number 5, 2016. Lordship will find that right in the middle of my paddy field, the earth cutting has started in 2016.
Okay.
Yes, and the vegetation has been destroyed, and some of my paddy field has also been taken for the construction. Serial number 6, Lordship.
Yes.
My apologies. In serial number 5 and 6, Lordship will find that on top of the paddy field, there is an indication of a constructional activity here, Lordship. This is my residence. This is my building, Lordship.
White color.
Lordship here.
White color. Okay.
Yes. And right below this, Lordship will find that there's a house below this.
Yes, yes.
This is the piggery project that was undertaken by me, Lordship. And in serial number 7, this is of 2018, and Lordship will recall that I've written to the Deputy Commissioner and the administration's civil SDO since 2017 and 18. So by now, the construction has also, the road has also developed into a better form, and my paddy field, this all were rendered unusable, Lordship. And because of this construction, the approach road also been cut off, and as a result, I could not transport my material to my under construction building. Serial number 8, Lordship.
Yes.
This is of 2020, Lordship.
Yes.
Now, this picture also depicts that I've stopped cultivating the entire paddy field that I used to cultivate. And the buildings all are left unattended. And there is habitation all over the building and the piggery project that I've undertaken, Lordship. And the last picture, serial number 9.
Just a minute. Albert. Ask them to follow. Ask them to follow and ask Abhishek to upload it. No. Yes.
The last photograph. This is of 2021.
Yes.
This also, the last streets, this also will show that no activities has taken place in my land. Even at this point, Lordship. Until date, it was rendered useless because of these constructional activities and the damage caused to my cultivable land, my piggery project, and my RCC construction, Lordship.
Okay. Now, when the assessment report of the damage,
Yes,
which has quantified the quantum of the damage,
Lordship.
on what basis that was made?
Lordship, that is not known to me.
That state
The assessment has been carried out by the
welcome
right
to it.
department.
Okay. But you are claiming that amount as compensation, which has been mentioned in the assessment report.
Lordship, for the reason best known to the state government, my piggery project, which has been affected, and for that I'm being aggrieved, and also the cultivable land, those assessment has also not been taken.
How much loss you have suffered as per your own estimate? You must have calculated.
Lordship, I have not made any individual assessment in that regard, Lordship.
No, when you are approaching the court for grant of compensation.
Lordship, my prayer before this honorable court is to direct the authorities to make proper assessment of the damaged properties and pay adequate compensation to the petitioner for the RCC building and other damages caused.
Yes. Anything else?
Lordship, in my earlier submission, Lordship will recall that I have produced 2 authorities in support of my contention.
You need not to again make submission on that, but you can cite those authorities.
Lordship, yes. Lordship, the first authority being 2016 2 GLT 154, Dokma Loya versus State of Arunachal Pradesh.
What it says?
Lordship, this matter pertains
No, what it says, why are you relying?
Lordship, my livelihood has been affected. And in this judgment, during the construction of a road by
Which,
the
which
BRTF,
para you are relying?
pardon me, Lordship.
Which para you are relying?
I'm relying on para 20 of this judgment, Lordship.
Para 20, okay.
While constructing this a road by the BRTF, a canal to a pedophile has been damaged. And in this judgment, the court, this honorable court has ruled that Lordship, this being a part of livelihood, it should be compensated for this, Lordship.
Okay.
And again, I'm also relying on Tukaram, Kana Joshi and others versus State of Maharashtra,
Citation.
2013, 1 SCC, page 353. I'm relying on para 17, 18, and 19.
Yes. What it says?
This method pertains to deprivation of property. I cannot enjoy my property anymore. Therefore, my property rights as well as Article 21 has been affected, Lordship, and because of which I'm also relying on
Entitled
this.
to get compensation.
Lordship.
Therefore, you are entitled to get compensation.
Lordship. And in the last occasion, Lordship, I could not produce these two authorities. However, these two authorities are directly connected to the core argument that I have advanced earlier. So
Yes.
I may be allowed to place two more judgments, Lordship.
Yes, yes, please.
1969, 3 SCC,
Yes.
769. Gunwan Core versus Municipal Committee, Batinda and others.
Para?
Lordship, I'm relying on para 14, 15, and 16. Lordship must have noticed that amongst the grounds raised by the respondent number 1, 2, and 3, one of the ground is that this writ court cannot entertain petitions which involves disputed question of facts. And in this judgment, Lordship will find that the Supreme Court ruled that writ petitions cannot be dismissed solely because disputed question of facts are involved.
Read that.
Para 14, Lordship.
14, 15, 16.
Married, Lordship.
Yes.
The High Court observed that they will not determine disputed question of fact in a writ petition. But what facts were in dispute and what were admitted could only be determined after an affidavit in reply was filed by the state. The High Court, however, proceeded to dismiss the petition in limine. The High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because in consideration of the petitioner's right to relief, question of fact may fall to be determined. In a petition under Article 226, the High Court has jurisdiction to try issues both of fact and law. Exercise of the jurisdiction it is true, discretionary, but the discretion must be exercised on sound judicial principles. When the petition raises when the petition raises questions of facts of a complex nature, which may for their determination require oral evidence to be taken. And on that account, the High Court is of the view that the dispute may not appropriately be tried in a writ petition. The High Court may decline to try a petition. Rejection of a petition in limine will normally be justified where High Court is of the view that the petition is frivolous or because of the nature of the claim made dispute sought to be agitated, or that the petition against the party against whom relief is claimed is not maintainable, or that the dispute raised thereby is such that it would not be inappropriate to try it in the writ jurisdiction for analogous reasons. 15. From the averments made in the petition filed by the appellants, it is clear that in proof of the large number of allegations, the appellants relied upon documentary evidence, and the only matter in respect of which conflict of facts may possibly arise relate to the due publication of the notification under section 4 of the collector by the collector.
Facts are a little bit different in this case. In this case, which you are relying,
yes,
the writ petition was dismissed in limine.
Yes, Lordship, this relates to acquisition. However,
But
Lordship,
it
may
means-
I read 16 also?
Yes.
16, in the present case, in our judgment, the High Court was not justified in dismissing the petition on the ground that it will not be determined dispute, it will not determine the question of fact. The High Court has jurisdiction to determine question of fact, even if they are in dispute, and the present in our judgment is a case in which the interest of both the parties, the High Court should have entertained the petition and called for affidavit in reply for the respondents, and should have proceeded to try the petition instead of relegating the appellants to a separate suit. And in the decision is in para 18, the appeal is therefore allowed. And the order. Lordship, the reason that I'm referring to this matter is that before that, my contention is that there is no disputed question of facts. Now that survey has taken place, joint verification has taken place, and now with the coming of the assessment, there is no question of facts anymore. Even if the matter is remanded or relegated to a trial court, the same facts will arise, because the same facts that the assessment is done by the appropriate authority. So there'll be endless litigation, Lordship, if these documents are not taken into consideration. Lordship.
Okay.
Lordship, apart from that, I'm relying on AP Electrical Equipment Corporation versus Tehsildar and others. This is an SCC online case, Lordship. 2025.
Para?
Lordship, I'm relying on para 47 to 53 and 57.
What it says?
Lordship, the fact of this case is that whether the brief fact, the question arose for adjudication here is whether the state has taken actual possession of a disputed land by way of Panchnama. It relates to acquisition procedure, whether it's valid or not, Lordship. And the decision in this case is that writ courts have the jurisdiction to decide the question of facts. And Article 226 does not debar or preclude a writ court to enter into a factual aspect of a matter, Lordship. It's a little lengthy, but may I be allowed to read the relevant?
No, what is the ratio on which you are relying?
Lordship, may I read the paragraphs that I'm relying upon? 47, Lordship.
today we don't want to keep it parted further.
Lordship.
You
I'm trying to be
you
as
have to
brief as
keep
possible, Lord.
yourself reminding about the same. That this is for the second time we are hearing this matter. So
Lord.
we have to complete it today. Yes.
Lordship, I'll quickly read
Para?
para 47. I
Yes.
understand that Lordship has been very gracious in being very patient.
Yes.
But allow me to read this. Para 47, one stock argument available with the state in this type of cases is that the question whether actual physical possession of the disputed land has been taken over or not is a serious disputed question of fact, which the High Court should not adjudicate or determine in exercise of its writ jurisdiction. As a principle of law, there need not be any debate on such proposition, but by merely submitting that it is a serious disputed question of fact, the same by itself will not become a question of fact. To put it in other words, having regard to the materials on record, which falsifies the case of the state government, then such materials should not be overlooked and ignored by the court on the principle that the issue with regard to the taking over of the actual position would be a disputed question of fact. Normally, the disputed question of fact are not investigated and adjudicated by a writ court while exercising powers under Article 226 of the Constitution of India. But the mere existence of the disputed question of fact by itself does not take away the jurisdiction of this writ court in granting appropriate relief to the petitioner. In a case where the court is satisfied, like the one in hand, that the facts are disputed by the state merely to create a ground for the rejection of the writ petition on the ground of disputed question of fact, it is the duty of the writ court to reject such contention and to investigate the disputed facts and record its findings if the particular facts of this case, like the one at hand, was required in the interest of justice. Number 49. There is nothing in Article 226 of the Constitution to indicate that the High Court in the proceedings, like the one on hand, is debarred from holding such inquiry. The proposition that a petition under Article 226 must be rejected simply on the ground that it cannot be decided without determining the disputed question of fact is not warranted by any provision of law nor by any decision of this court. A rigid application of such proposition or to treat such proposition as inflexible rule of the law or of discretion will necessarily make the provisions of Article 226 wholly illusory and ineffective, more particularly Section 10.5 and 10.6 of the Act of 1976, respectively. Obviously, the High Court must avoid such consequences. 50. In the aforesaid context, we may look into the decision of this court in the case of State of Orissa versus Dr. Binapani, DEI, AIR, so and so, in paragraph 6. At page number so and so of the said judgment, this court has been pleased to hold as follows. Under Article 226 of the Constitution of the High Court is not precluded from entering into upon a decision of question of fact raised by the petition, where an inquiry into complicated questions of fact arises in the petition under Article 226 of the Constitution before the right of the aggrieved party to obtain the relief claimed by the may be determined. The High Court may, in appropriate cases, decline to entertain upon the inquiry and make reference party to claiming relief to a suit. But the question is one of discretion and not of jurisdiction of the court. My Lord, for the sake of brevity, I will not read out all the entire paras that I'm relying upon. However, in brief, my Lord, the reason why I'm relying to this two cases is that this honorable court is not precluded, even if disputed question of facts has arisen. And the disputed of question of fact as raised by the respondent number 1, 2, and 3 is that firstly, whether damage has been caused, the present landslide, the present subsidence, and the present damages has been caused due to the constructional activities or not. That's one. Second is whether NHIDCL or the constructing contractor is liable to make the compensation. Firstly, Lordship, there was no history of landslides or no history of earthquake in this area before the constructional activities. No history being recorded that natural calamities has taken place in this area. Only after the construction and only after they have not taken due care in constructing breast wall and other constructional activities in order to protect my properties, damages has been caused. And therefore, and now that they have been participating, as I stated earlier, the question of facts is not there anymore. As regard to whether NHIDCL or the contractor is liable for compensation. Earlier, the respondent number 2 and 3, they have sought for implement of the contractor to be a party in this case, so as to determine that very question. However, this honorable court in its wisdom has ruled that the implement of the contracting party is not necessary, as the NHIDCL had been participating all along. And as far as the landslide being caused is being concerned, Lordship, in the affidavit filed by the additional affidavit filed by the respondent number 4, 5, and 6, Lordship, yes, at para 3, that by yes, at para 3, that by filing the instant additional affidavit, the deponent begs to state that the joint verification report of damages land, paddy field, approach road, and buildings belonging to Sri Thejao Sekose at Setsa Zubza area, Kohima, was conducted on 12/7/2023 after duly surveyed, checked, and verified by the technical staff of the Land Records and Survey Officer, Nagaland. However, this portion is important, Lordship. The approach road could not be indicated on the map as the landslide has already damaged the approach road. So after being surveyed by the technical staff, it has been established that there is a landslide has occurred. And Lordship, in conclusion, in my additional affidavit, Lordship, sorry, affidavit in reply, Lordship, affidavit in reply. Yes. Lordship, Annexure 8, page 27. Yes. I referred to this document on my earlier submission also, Lordship. Yes. So, Lordship, my main contention is, besides Article 21 and Article 300A being violated, Article 14 also has been violated in my case, because the landowners in the same stretch of land, Lordship, has been compensated for the damages caused to their land, to their properties beyond the ROW in this same project, Lordship. And this is document regarding that, Lordship.
What it says?
Because of landslide, document has been caused, Lordship.
Okay, we'll continue it too.
My Lord.
Okay.
Yes.
Lordship, I may be allowed to mention item 49. My
40.
senior was supposed to hear through VC, but there's some technical difficulties, so it can come up tomorrow, Lordship.
49 is what matter? Hearing?
So, yes, hearing. It's a short matter, Lordship. Tomorrow, Lordship. Kindly.
Not Mr. Foseko Forte, Learned Counsel, who is for the others,
I've taken the comment.
who submits that his senior, who is the conducting counsel for the petitioner, was to appear in this case today through video conferencing. However, due to some technical difficulties, same may not be done, and he seeks leave of this court for fixing the matter. He seeks a short adjournment on that ground and prays for listing this matter tomorrow. He also submits that he has taken consent from the learned counsel for the respondents, who has no objection to his prayer. Hence the prayer is allowed. Let this matter be listed on 19th 8/2025.
The interim, Lordship. Kindly take
The
it.
interim shall continue till next day.
Kindly oblige me, please.
We'll continue at 2.
Lordship.
REV 3, 1 equal to 4, lane so and so, dated 25th January 2021, to inform all the beneficiaries affected due to the landslide that occurred on 6 October 2020 at Perima village due to expansion of 4-lane national highway from Dimapur to Kohima, 124 km to 158 km at Perima village under Kohima district, under Dimapur district, Nagaland, structures outside ROW. That compensation for damaged structures shall be paid in conference hall of the Deputy Commissioner on 27 January 2021 from 1 p.m. onwards. The chairman, head GB, and members of the concerned village council are hereby informed to be present.
Is there any document or anything to show
Lordship.
that your damages to your property was also caused due to landslide?
Lordship, there is no. Earlier, Lordship, I was the affidavit filed by the state in their additional affidavit. The state also has stated this in their affidavit. Except for this, there is no separate document to show that this very
where the state has stated in their additional affidavit.
Additional affidavit at
para 4
at para 3, Lordship. Last second line, Lordship will find that
as the damage. Which line? Please read.
Pardon me, Lordship.
Please read.
Lordship. That by filing the instant additional affidavit, the
relevant para only.
Okay. However, the approach road could not be indicated on the map as the landslide has already damaged the approach road. So because of the landslide, the approach road has been damaged. Now, because of the same landslide, subsidence has been caused. Severe subsidence has been caused to my cultivable paddy field, and because of which, because of the same landslide, my property also has been damaged, Lordship.
No, whether they have acknowledged it, that your property was damaged due to landslide caused due to construction of highway.
Lordship,
have they acknowledged?
No, Lordship.
They are countering it.
Lordship,
their contention is that it is not due to landslide caused by construction of road.
Lordship. However, they have not shown anything in that regard also, that it was not caused by, it was not on account of the construction activities that this landslide has occasioned. Prior to the construction of this very road, there was I have shown your Lordship the photographs also. There was no history of landslide, but since after the construction, no proper protection wall has been constructed. In the correspondence of 2018, it has already been intimated to the NHIDCL that proper protection breast wall should be constructed so as to arrest further damages. However, this was not done so. And in the affidavit of the respondent number 4, 5, and 6, that is the state, Lordship will find that all these communications has been given to the NHIDCL. Lordship will find this in affidavit in opposition on behalf of respondent 5. Has your lordship got it?
Yes.
In the first para, lordship will find that the respondent number 5 has been duly empowered to authorize respondent number 4 and 6. The relevant para is in para 7.
Yes.
That with regard to the statement made in paragraph, I continue.
Yes.
5, 6, 7, 8, 9, 10, 11, 12, 13, and 14 of the petition is the answering deponent humbly begs to mention herein that all correspondences, complaint relating to the grievances of the petitioner received from the petitioner has been submitted to the respondent NHITCL. So right from 2017-18, all these correspondences has been forwarded to the NHIDCL. They have been intimated according to the state respondents. And in 2018, the document which I've shown your lordship earlier, they have given suggestion that protection wall should be constructed. And therefore, there is no question. No question remains as to who has caused this damage anymore, lordship. And lordship may also kindly appreciate the fact that it is the NHIDCL who requested the state authorities to go for a joint verification in order to assess the damages caused to the present petitioner. Damage and loss. It is not to ascertain whether NHIDCL has actually caused the damage or not. It is
This is the quantum.
to ascertain the damage and losses. They could very well, if they are denying, they may not be a part of this assessment also, verification process also. But they took part in verification.
Okay.
Now they are taking a U-turn. So lordship, coming back to the document that I'm relying on, lordship. At page 29. At page 27, the Deputy Commissioner has notified the head GPs and the other village authorities for the disbursal of the damage compensation cost to the various landowners.
In your
Page
affidavit,
29.
in your affidavit in reply.
Yes, lordship.
Yes.
Compensation for damaged structures, plantation crops affected beyond ROW at Perima village for expansion of 4-lane National Highway 29 from Dimapur to Kohima, 124 Kohima, 158 to 158 Kohima, Dimapur, Nagaland. And the list of compensated individuals are in page 30, 31 till 34.
Okay.
Therefore, lordship, to sum up my submission, my right to livelihood, which is a part of Article 21, right to have access to my residence, right to live in that residence has been affected. And when I mention right to livelihood, it includes the cultivable paddy that has been damaged was rendered useless now.
Okay.
And then the piggery project that has been undertaken by me, lordship, that has also been affected. and because of which that also has been verified, and it has been the same fact has been established in the civil SDO's 2018 document also, Lordship. Secondly, Article 4, as I've stated, Article 14.
Okay.
Yes.
Yes, Mr.
Unless your Lordship needs any further clarification, that's all from me.
Yes, Mr. Sentian. You are NHIDCL.
Yes, my lord.
Respondent number?
1, 2, and 3, Lordship.
Yes.
One, yes.
What is your contention, main contention?
Firstly, Lordship, there are disputed question of facts here, Lordship.
What are those questions?
One, participation does not mean consent, Lordship. Of course, on that day, Lordship, we went, but we were present on that side, Lordship. However, when making the assessment, Lordship, the quantification of the damages, Lordship, and whether it was actually done by the contractor or whether it was caused by an act of God, or whether the petitioner himself, through his negligence, had caused the damages. Those, in that decision making, we were not allowed to participate. It's just that on that day we went on the fourth assessment. On the earlier occasions, we were not invited. We went and then a picture was taken. We were made to sign on the list of persons present on that day. Some engineers from the state departments were also there, forest department representatives, the petitioner, the counsel for the petitioner. But besides that, Lordship, the state government, because we are the ones, Lordship, the union is the one who is going to make the payment, not the state government. So we should have been taken into confidence. But that was not done.
You were there. You were there.
On that day, Lordship.
On which day?
On that day, Lordship, where we were taken to the property.
Why?
It was shown around, Lordship, but in order to arrive at a conclusion that it was caused either by an act of God or by the contractor employed by the NHIDCL or through the negligence of the petitioner. In order to arrive at that decision, a discussion should have been held, an exchange of opinions. We were not allowed to participate in that process.
What was the nature of damages which you noticed?
Lordship, there were landslides.
Landslide.
Yes. And there is allegation that, Lordship, due to the disposal of earth after the excavation, Lordship, in the petty field of the petitioner, the petty field has been damaged, Lordship. However, Lordship, we have disposal sites for excavated land. We have specific assigned disposal sites, and the excavated earth, excavated earth is only disposed on those areas. And which is why, Lordship, this is the Kohima Dimapur Road, which many of us take constantly, frequently.
How the building of the petitioner got damaged?
That, Lordship,
due to landslide.
No.
He says that there many cracks have come in.
Yes,
it
Lordship.
Is now unusable.
That, Lordship, whether the relevant factor, Lordship, whether it was caused by us, whether it was caused by them or by an act of God, Lordship, that there should have been an exchange of opinions, expert opinion, Lordship, not just a layman opinion between the engineers, Lordship. Now, secondly, Lordship, in order to arrive at those facts, Lordship, this court is ill-equipped, Lordship, under Article 226, because evidence has to be taken. Examination has to be held, Lordship. That is not there, Lordship. Also, Lordship.
No, one query.
Yes.
Why are you not accepting the assessment made by the state government? State government has made an assessment.
Yes, Lordship.
Main reason is you were not taken into consideration.
Yes, Lordship. Secondly, Lordship also will notice that the Forest Department also have given their own assessment, Lordship. Now, for a work that was executed in 2016-17, Lordship, how can the forest, for cutting down of trees, for felling of trees, Lordship, in 2024, how can the Forest Department make assessment in 2024 after the passage of 7-8 years, Lordship? Now, there has been some, Lordship, some unfairness. They have not discharged their duty, Lordship, as expected from an officer of the state government, Lordship, occupying a high position.
Yes.
Which is why, Lordship, the compensation amount, it's not meager, Lordship. It's not reasonable also. It's more than 1 crore.
Yes.
And for the felling of trees alone, it accrues to 13 lakh something, Lordship. Now again, Lordship, my learned friend was also mentioning about that, Lordship, in his submissions. If my Lord will come to the array of parties, Lordship, in the writ petition, the writ petition that the petitioner has filed, the last respondent, Lordship, Oasis Technocons, Lordship.
Yes.
This is the independent contractor that the NHITCL have engaged in order to execute, Lordship, construct the road, Lordship. Now, this is the second contractor, Lordship. Earlier, there was one contractor who actually did the earth excavation works in the work in question. Now, Lordship, these are independent contractors. We don't share a master and servant relationship. The law is clear on that, Lordship. The contractor is not an employee of NHITCL. They are an independent entity, an independent firm altogether, Lordship. And that the legal maxim, respondent superior, shall not apply, Lordship, here. The third legal principle of master and servant relationship, vicarious liability, Lordship. Now, Lordship, before I come to the question of law, Lordship, the MS Technocons, Lordship, the contractor who was the second contractor who was appointed after the first contractor's contract was terminated due to the slow progress of the work, Lordship. So the first contractor was not implemented, the second contractor was implemented, the second contractor came with an interlocutory application before this Honorable Court, IA 33 of 2024, saying that we were not the one who executed the earth cutting, earth excavation, and as such, we may be removed from the area of parties. So, Lordship, the NHITCL did not oppose because we know, Lordship, that earth excavation works was done by MS Kayatri, the first contractor, Lordship. The petitioner also did not oppose. He was removed, Lordship. Now, Lordship, after that, Lordship, actually, a work which should have, in my understanding, Lordship, in my humble understanding, Lordship, which should have been done by the petitioner, the implement of the first contractor. So, we, the NHITCL, Lordship, instead of the petitioner, we filed one interlocutory application, IA 119 of 2024, Lordship. However, praying for impleting of the first contractor, that is MS Kayatri. However, the petitioner objected, Lordship. And perhaps because of the fact that, Lordship, the petition has been pending since 2022, Lordship, and the IA was filed only in the year 2024 after the removal of the second contractor, Lordship. The IA was
Well-
also,
Dismiss.
yes, it was dismissed, Lordship,
You
by order dated 22 of August 2024, Lordship.
you have not preferred any appeal against that.
No, Lordship,
Okay.
I did not, Lordship. Now, Lordship, there is the legal difficulty, Lordship, that arises is we have stated all these facts in the IA also. Now we have filed additional affidavit before this honorable court, placing the agreement between the independent contractor and the NHITCL on record, saying that, Lordship, the additional affidavit, Lordship, that I have filed on 5th of September 2024 clear under Article 3, Lordship. If at page 9, my lord, annexure P, there is an agreement, a contract agreement, that if the contractor adopts a wrong methodology and if loss is caused to the union or to the NHITCL, Lordship, then it is the contractor who shall be liable. Now, Lordship, if this was a case where
Where is that clause?
Lordship, page 9, obligations of the contractor, Article 3. If I may be allowed to read.
No, which one you are relying? You read directly there. That the
Lordship,
towards the
3.1.4.
yes, please read.
The contractor shall remedy any and all loss or damage to the project highway from the appointed date until the end of the construction period at the contractor's cost, save and except to the extent that any such loss or damage shall have arisen from any default or neglect of the authority. Authority means the NHITCL, Lordship. The next point, Lordship, the contractor shall remedy any and all loss or damage to the project highway during the defects liability period at the contractor's cost to the extent that such loss or damage shall have arisen out of the reasons specified in clause 17.3. 3.1.6, the contractor shall remedy any and all loss or damage to the project highway during the maintenance period at the contractor's cost, including those stated in clauses 14.1.2, save and except to the extent that any such loss or damage shall have arisen on account of any default or neglect of the authority or on account of a force majeure event. The contractor shall, at its own cost and expense, in addition to and not in derogation to its obligations elsewhere set out in this agreement, make or cause to be made necessary applications to the relevant government instrumentalities, with such particulars and details as may be required for obtaining applicable permits set forth in Schedule F, and obtain and keep in force and effect such applicable permits in conformity with the applicable law. B, procure as required the appropriate proprietary rights, licenses, agreements, and permissions for materials, methods, processes, and systems used or incorporated into the project highway. Make reasonable efforts to maintain harmony and good industrial relations among the personnel employed by it or its subcontractors in connections with the performance of its obligations under this contract, under this agreement. Ensure and procure that its subcontractors comply with all applicable permits and applicable laws in the performance by them or any of the contractor's obligations under this act. Not do or omit to do any act, deed, or thing which may in any manner be violative of any of the provisions of this agreement. Cooperate with and facilitate the authority in the implementation and cooperation of the project in accordance with the provisions of this agreement.
What NHIDCL was constructing highways.
Yes, Lordship. And J, Lordship, not interfere unnecessarily or improperly with the convenience of the public or the access to and use and occupation of all roads and footpaths, irrespective of whether they are public or in the possession of the authority or others. Now the petitioner has come up with the contention that his approach road was used by the contractor, Lordship. Now, this is also in violation of the contract agreement between the NHIDCL and the contractor, Lordship.
But that was the agreement between you and the contractor.
Yes, Lordship. Now, Lordship, that contractor is an independent contractor, Lordship. This is important, Lordship. He is not my servant.
But he's a stranger to the present petitioner.
No, my lord, he is not a stranger to the present petitioner, Lordship, because, Lordship, the cause of action, Lordship, that he is alleging, that can only be answered, Lordship, by the contractor, because as per the agreement that we have with the original contractor, the first contractor, Lordship, it is the first contractor who must compensate, Lordship. If it is found, if it is at all found, Lordship,
Okay.
that compensation must be paid, Lordship. Now, my lord, in brief, Lordship, I may be allowed to refer to a single decision, Lordship, 2021, 7 SEC, 151.
2021 7 SCC.
151.
Yes.
Paragraph 23. It appears at page 170. This is a judgment delivered by Justice Rohinton Nariman.
Yes.
Paragraph 23, if I may be allowed to read, my lord.
Yes.
It's a long paragraph, but I'll read only
Please read.
the first para, Lordship. First subpara. 23. After referring to several judgments of this court, the court in Silver Jubilee Tailoring House then referred to judgments of the English and American courts as follows. 19. In Cassidy Webster's Ministry of Health, All England Reporter at page 579, Lord Justice Somerville pointed out that the test of control of the manner of work is not universally correct, that there are many contracts of service where the master cannot control the manner in which the work is to be done, as in the case of a captain of a ship. Now, Lordship, paragraph 24, which appears at page 172.
Yes.
Ultimately, the court in Silver Jubilee Tailoring House found that two important considerations clinched the issue in favor of deciding that the persons employed were employed wholly or principally in connection with the business of the shop. First and foremost, machines on which sewing took place were supplied by the proprietor of the ship, and secondly, supervision and control in tailoring business terms would include the right to reject substandard work. These factors were held to outweigh the fact that such persons did not have to work exclusively for the owner of the shop, as also that they are not obliged to work for full day. Now, Lordship, here as well, in our case also, Lordship, the contractor, the independent contractor, Lordship, not just a contractor, he has a contract of service, Lordship, not a contract for service, Lordship. He is not an employee, Lordship, of the NHIDCL. And how the work, the minor details in how the work is to be executed, the methodology that he has to adopt in executing the work, the NHIDCL does not have control over it, Lordship. The independent contractor, he decides a methodology that has to be adopted, Lordship. And for us, if the work is done, Lordship, and within the time frame that is being given to the Lordship, we are satisfied, Lordship.
What NHIDCL does?
We
What it
float tender, Lordship, and in that, Lordship, a DPR is prepared, Lordship. How, suppose, granular subbase, the bituminous layers, how they are to be, how much density it must be, Lordship. And if retaining wall is to be constructed, Lordship, then how it has to be constructed, where the thickness, the width, Lordship. This,
Whether you monitor the execution.
Lordship, for that as well, Lordship, we appoint an independent engineer called the authority engineer, which is under the contract, Lordship. Which is why, Lordship, in the PIL between Kohima and Mao, Lordship, I am representing the authorities engineer, Lordship.
Okay.
So in every contract, Lordship, there is a provision for appointing an independent engineer to supervise the work, Lordship.
Okay.
Now, Lordship,
Yes.
the next problem, the legal problem that we have is, Lordship, when we do not share a master-servant relationship, then, Lordship, when we have an agreement, Lordship,
Yes.
for compensating the union or the NHSL, or for that matter, any persons who makes claim with the independent contractor, Lordship, without him being present in the case, can a legally enforceable order be passed, Lordship? Because it is him who must make the payment, not the NHIDCL.
Okay.
The law is very clear, Lordship, that no adverse order can be passed behind the back of a person adversely affecting his rights, Lordship. Otherwise, Lordship, I may be allowed to place two decisions, Lordship. In order to show before this honorable court that this honorable court may not be the appropriate forum, Lordship, to adjudicate the present matter. I'm not saying that, Lordship, they don't have a case, Lordship. They may have a very good case, Lordship. But this honorable court, sitting under Article 226, Lordship, may be ill-equipped. Para 16, my lord. I would like to read para 16, 17, and 18. These are very short paragraphs, Lordship.
Yes. Yes.
Now, as far as the reliance placed upon the decisions of this court by the learned senior advocate appearing on behalf of the respondent, referred to herein above are concerned, the question is not about the maintainability of the writ petition under Article 226 of the Constitution, but the question is about the maintainability of the writ petition against the order of assessment by passing the statutory remedy of appeal. There are serious disputes on facts as to whether the assessment order was passed on 23/2020 or 14/7/2020 as alleged by the SSC. No valid reasons have been shown by the SSC to bypass the statutory remedy of appeal. This court has consistently taken the view that when there is an alternative remedy available, judicial prudence demands that the court refrains from exercising its jurisdiction under constitutional provisions. 17. In view of the above and in the facts and circumstances of the case, the High Court has seriously erred in entertaining the writ petition against the assessment order. The High Court ought to have regulated the writ petitioner SSC to avail the statutory remedy of appeal and thereafter to avail other remedies provided under the statute. 18. Under the circumstances, the impugned judgment and order passed by the High Court is hereby quashed and set aside. Now, Lordship, this is the last.
Yes.
Paragraph 8, my lord. Considering the rival contentions of the parties and the interveners, coupled with the fact of pendency of the civil suit as noted herein before, it is clear that the present writ petition raises highly disputed question of facts, which would require the leading of evidence and the examination and cross-examination of witnesses, and which are therefore not amenable to being adjudicated under Article 226 of the Constitution. In so and so, it was held by the Supreme Court that it is the settled legal position that where disputed question of facts are involved, a petition under Article 226 of the Constitution is not a proper remedy, Lordship. Now, Lordship, in the assessment order, Lordship, that has been provided, that has been relied on, Lordship, by the petitioner, there is no conclusion, opinion, Lordship, or reason showing that, Lordship, NHITCL is at fault, or that whether it was the act of God or whether it was due to the negligence of the petitioner, or whether, Lordship, it was due to the wrong methodology adopted by the.
Where is that assessment order? Page
The-
number?
It is part of the affidavit filed by the state respondents, as well as the affidavit in reply filed by the petitioner, my lord. Page number 9, my lord, of the
1, 2, and 3. Affidavit in
affidavit filed by the state respondents, lordship, at page 9, annexure 3.
state respondent is respondent number 5.
Yes, my lord.
There is no page number 9. Respondent number 3.
Respondent number 5. I received
Yes,
the
re-
same on 5th of September, my lord, 2024. Page 9.
5th of September.
Yes, my lord.
That is additional affidavit.
My lord. Additional affidavit, lordship. Affidavit for and on behalf of the respondent number 5, bringing on records the joint verification report conducted on the land property of the petitioner.
I'm not getting. I'm not getting that.
I mean, if receipt from the
See from the. It is there somewhere. I don't remember.
in the affidavit in reply of the petitioner as well, lordship, it is at annexure 7, page number 26. The affidavit in reply is a thick affidavit, lordship. It's thicker than the other affidavit, so I believe it will be easier for my lord to look at it.
Affidavit in reply of.
The petitioner, my lord. To the affidavit in opposition filed by the respondents 1, 2, and 3.
Yes, page number.
26, lordship.
Let me take it back. Yes, what do you want to show?
Lordship, here, there is nothing. They have simply assessed the damage, attributing the damage to me, lordship, to the NHITCL, or for that matter, to the independent contractor appointed by the NHITCL.
What was the enclosures?
Enclosures, lordship, this the assessment, lordship, made by the forest department, lordship, was also one of the enclosures, lordship. And the assessment, Lordship, made by the state representatives.
No, now if you read the assessment report, first
Yes,
para,
Lordship.
first para, just above the table, with reference to,
Yes, Lordship.
read it.
With reference to the subject cited above, I am directed to submit here with estimate for property damage along with department assessment and survey report in respect of the Chao Sekosi at so and so. Under four
lane.
Yes, Lordship.
Beyond ROW.
Yes, beyond right of way.
Which indicates that this damage was in relation to this 4 lane.
Lordship, but Lordship, they have not arrived at the. We cannot read between the lines, Lordship.
No, what it means.
It means that Lordship.
Assessment and survey.
Yes, it means that Lordship beyond ROW. In simple layman's term, Lordship, beyond ROW, some property have been damaged.
Yes.
Now that damage, whether it was an act of God, whether it was the act of the independent contractor appointed by the NHITCL, or whether, Lordship, it was due to the negligence of the petitioner himself, that is not mentioned. Nothing is attributed to the NHITCL or for that matter to the independent contractor, despite the fact that he has not been implemented.
But there is an indication that this damage was because of this 4-lane road project. Who was at fault, that has not been mentioned.
Yes, Lordship.
But it was because of this 4-lane project, and you were the executing authority. NHIDCL.
Yes, Lordship. Executing authority, Lordship, the independent contractor, Lordship, appointed by the NHIDCL, Lordship, he is the one who actually executed the work at the ground level, not the NHIDCL, Lordship. Not a shovel
24.
of the land, Lordship.
This was done in pursuant to any court's order.
No, Lordship.
Why the subject shows the reference of this case?
I believe, Lordship, because there was a pending matter before this honorable court. And this is not the first assessment, Lordship. During the pendency of the writ petition, there were also other assessments done. But during those assessments, Lordship, the NHIDCL representatives were never invited. And even during the fourth assessment, Lordship, we were invited, but we were used as a dummy, Lordship. No opinion was taken from us.
Yes, one query to Mr. Kizi. Now, it has been shown that against building instruction 99,69,936 was assessed to be the quantum of loss. What was the basis? Any supporting documents?
Lordship, I was
it is
the one
not-
who has done the assessment. It was the department, so I'm
It
not
is
in a
with
position
you.
to answer his lordship.
Regarding the assessment and the rate applied for the damaged building. It is applied as per the Nagaland PWD schedule rate of 2016.
No, you have justified somewhere.
No, it is just on the page number 16. On the top, it is mentioned like that.
Page number 16 of
16, yes.
16 of what?
As per.
16 of?
damage, yes.
No, 16
On
of
my
what?
affidavit, additional affidavit dated 5/9/2022. 2024. Page number 16. Additional affidavit filed on 5th September 2024.
Where, yeah.
No.
Yes. As per Nagaland SOR 2016. The CWD, they have a schedule of rate.
Page number 16.
Page number 16.
Damage assessment of structure and properties during construction of Kohima Dimapur or Lane Road project situation. And followed by the second line, small leader. As per Nagaland PWD schedule upgrade SOR 2016.
You are respondent number 1, 2, and 3. Respondent number 5, 4, 5, and 6.
State respondent.
Benefits. Affidavit in opposition for respondent number 4, 5, and 6.
File on 5 September 2024. We have filed 2 additional affidavit. So subsequent one. Filed by the respondent number 5. With this given letters, but shall I this one 5. 1 to 4, 9 to 6.
Yes, page number.
Page number 16.
It is a table.
Damage heading is damage assessment of structure and properties during the construction of Kohima Dimapur 4-lane road project. Situation.
Okay, so there is some basis.
We just, the department has mentioned as per the Nagaland PWD schedule of rate SOR 2016.
This has not been challenged by the NICDL. The computation,
No, Lordship.
you are not challenging.
No, Lordship.
You are only challenging that the principle of respondent superior is not applicable to your case.
Yes, Lordship. Yes.
And
Lordship.
you are if there is any liability, it is
Yes.
of the first contractor.
Yes, Lordship.
That is your
Yes, Lordship.
stand.
Yes, Lordship. And Lordship, an order cannot be passed behind the back.
And he is a necessary party.
Yes, Lordship. Yes.
If we go by your submission.
Yes, if we go by our agreement, Lordship, that I have placed before this honorable call.
No, what would have, what would be the consequence of violation of any stipulation in your agreement?
The independent contractor, Lordship.
Suppose there is a contract between you and the first contractor
Yes, Lordship.
and they violate,
Yes.
then what would be the consequence?
If there is no indemnity clause, Lordship, for causing losses to third party, Lordship, while executing the work, then the NHITCL shall be liable, Lordship. But when there is an indemnity clause, like in our instant case, Lordship, there is a specific clause. Then it is the independent contractor. He has already agreed, Lordship. And without him,
But that independent contractor is a stranger to the petitioner, what I'm saying.
yes, Lordship.
Between that petitioner and independent contractor, there is no contract.
Yes, Lordship. Lordship, yes. That is an agreed position, Lordship. But, Lordship, the petitioner, he himself implicated the contractor, though on a wrong impression that earth cutting was executed by the second contractor, that is MS Oasis Technocons, Lordship. Now, that has been removed, Lordship. That means he himself is aware that, Lordship, the contractor is a necessary party. We are not trying to pass the buck, Lordship, around. We are saying that, Lordship, there is a specific agreement, Lordship, that agreement must be respected, Lordship, and it must be abided by the parties. And even after, Lordship, we have brought the agreement to the notice of this Honorable Court, Lordship, and to the notice of the petitioner, Lordship. No steps are being taken, Lordship, by the petitioners to implicate the original contractor, Lordship, who is actually liable, Lordship.
Okay.
And, Lordship, this question of facts, Lordship, in my respectful opinion, Lordship, my humble opinion, Lordship, can be decided only before the civil court, Lordship.
Okay, yes, Mr. Imso.
Yeah, please, Your Lordship, in the present nature case, we act like a postman or say felicitator. As and when the ministry comes to us with a certain issue, we communicate with the landowner, with the respective landowner, or with the local people. At the same time, as and when the landowner or villagers have issue with the ministry, and we are the one to preach. So here also, as per the direction of the parties, we acted like a felicitator. So also in the present case, we filed 3 affidavit. And first one was affidavit in reply, position. Followed by we filed another additional affidavit on 4th May 2023. So in that affidavit, as per the report, we have assessed the petty field and the upper short of the petitioner as alleged by the petitioner. And followed by that, the NHRECL, which also a part and parcel of the documents of the re-petition. The NHRECL GM, General Manager, has written to us on 10 June 2022 once, followed by another letter 15 September 2022 for joint verification, which was highlighted by the petitioner counsel. So on the basis of 2 leaders, we have conducted a joint verification. So,
Joint with the NHIDCL.
yeah, including the NHIDCL.
Okay.
So we make the assessment, and the building damage of the building also we have assessed. So also the petty field and the trees. Trees was assessed by the forest department. So all the concerned department were involved. We, as per the requirement and as requested by the NHIDCL, we have submitted our assessment to the General Manager NHIDCL. So that is our part. And in our report, in the assessment, that is in my affidavit, additional affidavit dated 5th September 2024, Annexure 3, page 9, it is clearly mentioned beyond ROW. So we infer that it is a additional damage caused to the petitioner or suffered by the petitioner. So in that case, as per the requirement and as insisted, we have submitted the report. So we have discharged our duty here.
Okay.
So whether the independent contractor is liable or not, whether there is a master and servant relation is there or not, that is not our subject. But as per the as registered, we have submitted our assessment. So that is my pre-submission. And in case if any law and order arise, and we are the one to look after the law and order also. So that is my pre-submission.
Heard Mr. T. K.C.
My Lord,
Oh,
my Lord, I may be permitted to.
yes.
But one or two points raised by the.
Yes, please.
Which I did here. Lordship, as far as.
Be brief. Be brief.
Lordship, I'll be as brief as possible, Lordship. As far as the question of facts is concerned, Lordship, nowhere did the NHIDCL specify in their affidavit the factors that has occasioned the damages. Nowhere, nor they have not made any contrary technical assessment in their affidavit also that apart from landslide or apart from the road construction, the damage has actually caused by another factor. They have not made any submission in that regard, nor in their also. There's no.
But they have, council has submitted that it
Yes.
may be by the act of God or by his own.
Maybe, but
that statement is not there in their affidavit. That you want to say.
No, Lordship, in their statement also, in their affidavit also, they have mentioned, but they did not specify the factor which is responsible for the damages caused. And my submission is
It is not like this.
apart from the road construction, there could not be any other factor because of the road construction, landslide has started occurring. So the question as to whether a determination of fact is required or not, no, Lordship. And Lordship, as far as the impletement is concerned, initially I have implemented Oasis Technocons,
Second contractor,
the executing contractor at that point. However, as mentioned by this honorable court's order, they have been let off. And at that point, the replacement was not raised by the NHIDCL also. And at the same time, later on, when the NHIDCL tried to implement the contractor in order to frustrate my case, Lordship, after a lengthy hearing, after a proper hearing, the court has decided that implement of the contractor is not necessary, owing to the fact that NHIDCL was aware and had been participating all along.
Okay.
And Lordship knows that this order was never challenged.
Okay.
Besides, Lordship, as far as the contractor's agreement is concerned, Lordship, this is, at best, this is a private agreement between the employer and an employee, between the NHIDCL and the contractor. Now, can my fundamental right, I've been deprived of my property, can this fundamental right be frustrated, be allowed to frustrate my, be allowed to be frustrated just because there was a private agreement exists between two parties, Lordship? And Lordship, lastly, the question as to whether when landslide occurs because of the construction activity of the respondents, when landslide occurs, who is responsible for paying the compensation, Lordship? Lordship will find this in page 28 of my affidavit in reply, that NHIDCL is the authority which has paid the compensation to the other landowners, Lordship. At page 28 of my affidavit in reply. That's all for my submission, Lordship.
Okay. Lordship, my lord has asked me a pointed question, whether we have agitated to the assessment made by the Deputy Commissioner, Lordship. It is the letter written by the General Manager, NHIDCL, to the Deputy Commissioner agitating the assessment report, Lordship, is at Annex A, page 8 of the additional affidavit that the NHIDCL has filed on 5th of September 2024.
Okay, I'll consider.
My lord, my lord.
Heard Mr. T. Kezi, learned counsel for the petitioner. Also heard Mr. Senti Anger, learned counsel for respondent number
1, 2, and 3.
1, 2, and 3, as well as Mr. Imtim Song, learned additional AG, appearing for the state respondents. Appearing for the respondent number 4, 5, and 6. The judgment hearing concluded, judgment reserved.
Lordship, I have a small request, Lordship. Assuming that the petition is allowed, Lordship, my remedy to approach appropriate forum challenging the assessment may not be closed.
Challenging the assessment.
Yes, my lord. Since I have already agitated, but agitating it before a higher forum, perhaps,
Okay.
as provided under the law.
Okay, otherwise, assuming
Yes.
that the petitioner is allowed, you always have remedy to file
My
an
lord,
appeal.
my lord, my lord.
Apart from that appeal,
Yes, yes.
do you have some other remedy?
I believe so. I believe so.
There
Lordship.
may be.
Yes, yes.
Okay.
Challenging this, I have other remedies also, Lord.
Okay.
Yes,
Okay, that I will move,
my lord,
if required.
my lord. Under section 3G, subclause 5 of the National Highways Act, I believe the NHIDCL have also a remedy to approach to go for arbitration.
Yes. Okay.
I'm obliged, my lord.
For unlisted motion, item number 54.
Where is the cause list? Just a minute. Keep this also. Yes, what is this?
This your lordship. Lordship, this matter is of contractual matter and is being filed seeking to quash and set aside the letter issued by the Northeast Frontier Railways, which is respondent number 6 in the instant petition. And the impugned letter that we are praying to seek to quash and set aside is in annexure 38, page number 315. Your lordship, the brief of the facts of the case is that the petitioner, he was awarded the contract on being successful in the tendering process. And according to the terms of the contract, the petitioner furnished BG bond amounting to rupees 52,24,848.97 rupees. This can be seen in annexure 1, page number 35, last paragraph.
So what is this? Page 35?
Yeah, the agreement between the railways and the petition. Your lordship, prior to this petition, the petitioner has already filed 2 petitions, WPC number 153 of 2024 and 4 of 2025 before this Honorable Court, challenging the arbitrary termination of the contract and subsequent issuance of a fresh contract for the same work to another party. However, both the petitions were disposed of with the direction that the parties shall proceed the dispute through arbitration. So thereafter, the petitioner, with the help of his legal counsel, has issued a notice for arbitration, initiation of arbitral proceedings to the respondent on 04/07/2025, which is in Annexure 36, page number 302 of the petition. The initiation for arbitration proceedings.
You just,
However, the petitioner was shocked to learn that the railways have issued letter to the bank seeking the encashment of the BG bond despite the initiation of the arbitral proceedings. This is the letter that we're challenging, which is in Annexure 38. as mentioned.
page number?
Page number 315. The last annexure, page number 315.
What is this? These are postal receipts?
Page number 315.
Yes.
315. This is the letter issued by the respondents, railway respondent number 6
At
to the
315,
bank
there is no letter.
for engagement. The arbitrage that is in Annexure 36, 302. The letter for arbitration proceedings issued by the petitioner to the respondent.
Pagination is not proper. 302 is the order of the court dated 14/4.
It's my lord, can I give you this?
No, you correct the pagination. What is the relief which you are seeking?
Yes, the relief that I'm seeking is to quash and set aside the engagement of PG bond that was given to the bank by the respondent for engagement of PG bond that was furnished by the petitioner during the initial proceedings of the contract. When both parties have already decided to go through arbitration process, the respondent have unilaterally taken the step to engage the PG bond.
Where is
without-
that? Where is that impugned order?
The letter or the
The-
court's order, your lordship?
No, the decision that the bond would be,
The court's order, your lordship?
no, you are aggrieved by,
Yeah, I'm aggrieved by the page number 315, annexure 38. 315 page, annexure 38.
pagination is not proper. Annexure 38 is at page 316, yes.
The issuance of this letter to the bank by the respondent for engagement of PG bond
Okay.
that was furnished by the petitioner during the initial stage of the contract.
Who is for the other side?
For the union, it's learned powerful Mr. John Mule.
Miss,
John Mule. John Mule. We have already furnished a copy.
Mr. Yangarwati,
No, Mr. John Mule.
where is he?
Furnished a copy this morning.
For respondent number one only.
What was the direction in the first writ petition which you preferred? WPC 153?
It's in Annexure 29, page number 256. Annexure 29, page number 256. Is for WPC 153 of 2024, which was filed for arbitral termination of the contract.
In the second order,
Page number 300, Annexure 35. This is for WPC 4 of 2025.
why second case was filed?
Pardon, Your Lordship.
Why the second?
The second was filed due to the same work order was announced in the website, and then the same work was given to another party for a higher contractual price. The first contractual amount was rupees 10 crore and few lakhs. However, the second one was rupees 12 crore and few lakhs, and it was given to some other party for
Yes.
the same work.
Yes, Mr. Yangarwal. You have anything to say?
Lordship, this railway, usually the railway, they have their own standing council.
Railway Standing Council is there.
Earlier there was one Sangtil.
Presently, you don't have it.
I don't know presently, I don't know whether they have or not.
Yes, Mr.
In the district they have.
So notice will have to go.
So let now, I think YB Gupta CGC is the standing council. Let notice be issued.
Heard, Miss. What is your name?
Wapang Lemna.
Heard, Miss. Wapang Lemna, Learned Counsel for the petitioner. Also heard Mr. Yangarwati.
Lordship, anyway, I'll make a reason. In the other petition also, Mr. Zeden only appeared. Anyway, I'll hand over the petition to him.
Also heard Mr. Yangarwati, Learned Central Government Council.
Your Lordship, if interim could be allowed to stay the said letter till the disposal of the present petition.
This writ petition has been filed under Article 226 of the Constitution of India by the petitioner, namely Messrs. Trident Enterprise, praying for enforcement of the fundamental rights as well as constitutional rights of the petitioner guaranteed under Article 14/21 and 300A of the Constitution of India. The petitioner has also impugned the letter dated letter number PNO BGC PNO/BGC/BKS/BG/82 Part 5 dated 8/8/2025, issued by the office of, where is this letter?
315 annexure 38. $315, the last page of the petition.
315
Yes, page number 315.
issued by the office of FANCAO within bracket /construction NF Railway, whereby the bank manager, Bank of Maharashtra was requested to arrange encashment of the BG bond of rupees 52,24,849 submitted by the petitioner against the work order number CA, work order bearing number CA number CON/D-K/2630 DT-12/10/2020 as the work order is not executed satisfactorily by the agency. Learned counsel for the petitioner has submitted that the original work order issued in favor of the present petitioner was arbitrarily terminated by railways.
They are arbitrarily terminated. That was already discussed in the previous case.
And accordingly, the petitioner approached this court by writ petition number 153/2024. Stop. The said writ petition was disposed of by a coordinate bench of this court by order dated 8/4/2025, whereby the parties whereby an indication was given that parties may take recourse to arbitration. However, learned counsel for the petitioner submitted that the petitioner, that the respondents again arbitrarily floated NIT dated 19/10/2024 for the same work for which the work order was earlier given to the petitioner, which compelled the petitioner to approach this court again by filing writ petition number 4/2025. The said writ petition was also disposed of by a coordinate bench of this court by order dated, which order?
14/4/2025.
Where is the
The orders in page number 300, annexure 35.
order dated 14/4/2025? Whereby the writ petition was disposed of with an observation that the parties shall be at liberty to settle their dispute by way of arbitration, by taking recourse to arbitration. Stop. Learned counsel for the petitioner has submitted that in the meanwhile, the petitioner has initiated the, where is that letter?
302, annexure 36. Page number 302, annexure 36.
You have given this notice to whom?
To the railways, respondent number 6.
Taken steps for initiation of arbitration proceeding by giving a notice to the railways for
And respondent number 2, 3, and 4, which are all part of the railways.
respondent number 2, 3, and 4. For appointment of an arbitrator. Stop. She, however, submits that in spite of that, by the impugned letter dated 8/8/2025, the Bank of Maharashtra was requested to arrange encashment of the BG bond. Stop. How you will suffer
Yes, Your
if
Lordship.
it is encashed?
If this is engaged, then Your Lordship, irreparable damage will be done. to me.
Why?
Because once the money is forfeited, I am not sure if I will be ever allowed or will be given an opportunity to get back that money. And the arbitration process is just on the way.
Learned counsel for the petitioner has submitted that since the money involved is a huge amount of rupees 52 lakhs 24,849. Hence, if the same is encashed before culmination of the arbitration proceeding, the petitioner would suffer irreparable loss. Issue notice to the respondents. Since Mr. Yangarwati, learned Central Government Council, has appeared for respondent number 1. And for other respondents,
By registered post, Lordship.
no formal notice need to be issued to the said respondents. However, as regards respondent number 2, 3, 4, and 5, 5 and 6, the petitioner shall take steps for issuance of notice to the said respondents by registered post with AD, as well as by usual mode, returnable within 4 weeks. Stop. In the meanwhile, considering the submission made by learned counsel for the petitioner, in interim, it is directed that the respondent number 6, who is the bank manager?
The bank manager, Your Lordship.
Bank has been
The
made
bank has been listed as respondent number 5.
respondent number 5
Okay.
shall not allow encashment of the BG bond of rupees 52,24,849 submitted by the petitioner, in pursuant to the impugned letter dated 8/8/2025, until the next returnable date, list accordingly.
Much obliged, Your Lordship.
For unlisted motion, item number 53.
May please, Lordship.
Yes.
Lordship, we have received the copy filed by the petitioner. However, Lordship, today we have moved for an unlisted motion. We make a prayer to the court, but the court has directed the state appeal to be listed tomorrow. So I had already filed my affidavit on behalf of respondent number 1 and 2. Whether the affidavit is on record or not, Lordship.
In this case,
Yes, we had filed our affidavit on behalf of respondent number 1 and 2.
okay.
Lordship, we are praying for 2 days to extend the period for 2 days in the interest of justice. Because
At what time whether any time has been granted for listing of unlisted appeal?
Lordship, the matter is to be listed tomorrow. And the seat which your Lordship has mentioned in the order as the last date, that is 18, Lordship, it is not 18. We are yet to receive the information. The last date for admission is yet to be notified, Lordship.
So,
We are moving an opinion before this bench, principal bench.
no, in your affidavit, what have you stated?
Lordship, I have stated that we have intimated to the counsel of the petitioner, that is my senior colleague, Siti Jamir, about the intention of the government of filing the appeal. I personally met him. I informed him whether he is in a position to accept the notice on behalf of the petitioner. On the same evening, his junior colleagues, that is Imtisanat, he informed me over the phone that he had informed the petitioner, and the petitioners is yet to engage them as their counsel. So the petitioner is very much aware of the appeal to be filed before the principal seat.
No, but mere filing of appeal may not help you unless a
Lordship,
stay is granted.
Lordship, yes, I have mentioned in my affidavit,
Ms. Sokre, in this case,
Lordship.
this court was made to understand that last date of the admission is 18th, Therefore,
Lordship, Lordship, on
therefore, therefore, time is of essence in this case. So,
Lordship,
and considering these facts only, the respondents were directed to comply with the orders within the timeline prescribed by the court.
Lordship, if I remember correctly, on the day of our hearing, we have stated that the last date is not 18. The last date is not 18, but when the order came out, it is mentioned as 18. So
No.
in my affidavit today also, I have mentioned that the
No,
last
Mr.
date for admission is not 18. So Lordship, I'm praying
okay.
for 2 days. Yes.
If I don't, if I can recollect properly, I made an oral query at the time of delivery of judgment that whether this date can be extended, 18th can be extended, and you submitted that it cannot be extended because seat is a very precious, MBBS seat is precious. That was your submission.
Your Lordship put a query
Now
in
you are making a submission exactly contrary to what you have submitted on that day.
Lordship, if I can read properly, your Lordship put a question on me whether the admission taken, whether that can be cancelled. So I say to your Lordship that once the admission is taken, the cancellation is impossible. Otherwise, I have not mentioned that the last date of admission is 18, your Lordship. And it is by record that we have informed.
It's okay. You are making wrong submissions again. You said that you have submitted that on that day that the seat will have to be returned to central government and by the state government if admission is not taken by.
Yes, true. Yes,
That
I
was-
agree to that. I say to that, Lordship. Suppose if it is the last date and if
Okay, now what is your justification for not complying with?
Lordship, I have mentioned in the affidavit that is at para 3.
Yes.
That the common judgment and order dated was passed on 14/8/2025. The next date, 15/8/2025, is an independent day. 16/8/2025 being holiday for
No,
Jamnastami.
these explanations are not acceptable. When time is of essence, in emergency situations, don't the government department work during holidays? Is it your submission because of holiday you are failing to comply with the court's order?
Lordship, may kindly appreciate that right after we received the court's order, we have taken the decision to file an appeal. So the appeal we have started at the first instant, we have taken all the possibilities, Lordship, at the earliest possible time. And the last day for admission is not 18th of this month. The college is yet to notify the last date for admission, Lordship. So since the state had already filed an appeal and which is to be listed tomorrow, Lordship, I pray that 2 days may be granted to us in the interest of justice, 2 days only. I'm praying only for 2 days, Lordship. And the petitioner, herself is aware that the state has already filed an appeal. If we have not informed her priorhand, that's a different issue. But Lordship, we had already informed her before I leave for Gauhati, Lordship. We will be serving a copy of the writ appeal to the person. Lordship, in the interest of justice.
No, I am not at all impressed with your submissions because in this case, specific time frame was granted and there is no bar in filing appeal in emergency case, even during holidays. There are instances. So your plea that holidays were there in between and the petitioner was knowing that would not save you from contempt.
Lordship, court's holiday is on 16, 17, and Sunday. Today is Monday. We pray to the Chief Justice to list the matter at 2. But the Chief Justice said the matter to be listed tomorrow. So Lordship, basing on that, we have already filed the filing number, everything I can provide to the petitioner, Lordship. So Lordship, I'm free
What is
for
the last date?
this.
Last day, on the day of passing the order by this honorable court was
No,
18.
no. My specific query is, as learned additional AG has been submitting that last day for taking admission.
That is why I'm
has-
coming to that, Lordship. On the day of hearing the case, that is on 14, till afternoon, it was 18th of August 2025. So accordingly, we made some, but we got information that 18 has been extended. Same day, that is on 14, extended to 18. But after the court proceeding was over, only then we came to know about this, number 1. Number 2, by filing the affidavit this morning, just now I have been served with a copy. In paragraph 5 of the affidavit, a categorical statement has been made, and the Learned Additional Advocate General has also made a submission that I have been informed. It's not that she came to meet me. I happens to visit the chamber, that is the residence room, after I visited the
No,
bereavement.
no, Mr. Zamir.
After the bereavement.
Even if you have been informed, it is between court and contender.
Exactly, Lordship.
Court has passed an order.
I'm coming to that, Lordship. Now that whatever has happened, I have already informed to the Honorable Court. Now, it is up to this Honorable Court and the contender. Mere filing of the appeal is not enough, and that will not absolve even the contempt, whether the contempt has been committed or not. My learned friend was referring to the filing of writ appeal and all that in the principal seat. That will not absolve whether the contempt has already been committed or not. And that these two proceedings are altogether different proceedings. A contempt proceeding is a different proceeding altogether, which we have brought it to the notice of this Honorable Court. The role of the petitioner comes to an end the moment we brought it to the notice of this Honorable Court.
Okay.
That is one. With regard to the appeal, Lordship is well aware about the implication of the CPC also. Unless there is a stay order, the order still remains, and my learned friend would not able to produce any order suspending the order passed by a Lordship on 14th of August 2025. So, Lordship, the documents are before Lordship. In my representation, which was submitted pursuant to the judgment, I have given my telephone number also, so that any communication, if necessary, can be intimated. We have waited from 3:30 to 6 o'clock on 14th evening. The director did not turn up, but additional director was there. Knowing getting the information that director is not coming, we had to leave because we cannot sleep there. And next day also, although we know that it is a holiday, we went and waited. It did not open.
Okay.
So that was the situation. And Lordship, I have already informed in the morning that the travel time to the designated college, it takes 2 days, minimum 2 days. So they are seeking 2 days time, so as to buy time so that everything will be frustrated.
Ms. Sokre.
Lordship, I pray only for 2 days in the interest of justice, and nothing prejudice will be made to the petitioner because the last date has yet to be notified. So since the appeal is to be listed tomorrow, Lordship, I pray that 2 days may be extended in the interest of justice.
Who will notify the date, last date of it?
The concerned medical college. We have reserved one seat in a particular college as directed by this court for the petitioner.
Has already furnished the dates of admission. I'm placing before Lordship.
Admission is going on, Lordship. Admission is going on, but the last date is yet to be notified. Admission is going on, but the last date is to be notified. So nothing prejudice will be made to the petitioner by extending 2 days in the interest of justice.
Why you want 2 days?
Because tomorrow, Lordship, our appeal will be listed before the Chief Justice Court.
So tomorrow you will be knowing whether any,
Yes, whether there is a stay or not, Lordship.
then we may fix it tomorrow at 4 p.m.
Lordship, if that is the Lordship.
Lordship, I have given the chart in the second last column. Lordship will find 22nd is date of training and reporting. Reporting stroke training. 10 occurs 2025 to 22nd occurs 2025. So as I have pointed out to Lordship, that 2 days journey time will be required. From day one, they have been taking time and one or the other pretext, but till date, they have not shown
No,
any
just
endeavor.
let me. As per your information, the last date is 22nd.
By medical council, Lordship.
Where is
No,
that?
Lordship, we are the authority who should receive the information, not the
No,
petitioner,
let me
Lordship.
put query. I am not believing whatever is being submitted at bar, but let me put queries. From where you are saying, Mr. Zamir, that it is extended to 22nd?
Medical council committee, Lordship.
Where is
MCC.
MCC 里面，就是说这个往比较的说，October之后，往这而且都是政治。
This is from website, Lordship.
So it is.
Actually, it is they who should produce this. They are the authority.
No, it shows that the verification of tentative seats would be in between 18th to 19th.
That is with regard to the central pool seat, Lordship, for the all government of India, which is conducted by the MCC.
Yes.
Here we are conducted by the state.
It is AIQ. That 15% quota seat. That is a different quota.
Yes, Lordship. So, Lordship, in that case, we can fix it tomorrow at 4 also. Or otherwise, Lordship may kindly extend 2 days.
No, suppose we fix it at tomorrow at 4.
Lordship.
If stay is granted by the appellate court,
yes,
matter goes to the appellate courts.
Yes.
Suppose if stay is not granted,
Lordship.
How much time will you require to comply with whether you have to comply with it before in that evening itself?
Yes, Lordship, if we lose the case in the appeal, then we have to stand by what your Lordship direction. So we have to comply within the time, Lordship. But Lordship, my prayer is that 2 days may be granted to us in the interest of justice. Since no last date has been notified, it will not prejudice the petitioner.
Whether the contemners are present.
Yes, they are present in person, Lordship.
People how much time will you take to comply with the order? Will you take the plea that office is closed by 4:30, so we cannot? Assuming that I am putting both of you a question.
Your Lordship.
Listen to my question. Assuming that the appellate court grants stay, matter ends, it goes to the appellate court's jurisdiction. But if stay is not granted, then you are under order of this court to comply with. If you don't comply, this court will invoke contempt jurisdiction against you. So, will it be possible to comply
Your Lordship,
in the tomorrow evening itself?
2 to 3 days, because there are
Why
a lot of
2 to 3
procedures,
days?
Lordship.
Why?
They have to sign bond agreement with medical department. They have to go around.
No.
They will immediately report us and when they inform.
What you have to do, I want to understand.
Your Lordship, we have to issue nomination after verifying all the documents.
Okay, then
then they will move around to get necessary authority signature for
You will give nomination letter to,
nomination letter to the petitioner.
as well as to the college.
Yes, all ministry as well as college and all the concerned
How
authorities.
much time will it take?
So at the most 2-3 days.
No, why 2-3 days? Okay, we'll decide it tomorrow.
Lordship, 151 seats have been given on one single day.
No, that we
And
will,
they are seeking 3 days time to grant one seat.
that
This is nothing but delay tactic.
that we will decide tomorrow.
Your Lordship.
And they have already committed a contempt. Lordship, submitting a contempt petition.
Subject to the appellate's court order, we will.
My respectful submission, Lordship, appellate court jurisdiction is one aspect. It's a parallel proceeding. And your Lordship is exercising the contempt jurisdiction, Lordship.
Yes,
Under Article 215 and 2.
Amita, Dikho. Yes, take your seats, please.
Thank you.
In pursuant to the order passed in the morning today, both the contemners, namely Srimati Sarita Yadav, the Secretary to the Government of Nagaland, Department of Higher and Technical Education, and what is ER? Engineer Vipul Ho Lohungu, the Director, Department of Technical Education, are present before the court in person. Stop. It appears that both the contemners have filed their affidavit in opposition. Stop. All heard Ms. V. Sokre, done an additional AG appearing through video conferencing, who has submitted that the respondents have preferred an appeal before the principal seat of Gauhati High Court against the judgment with regard to which this contempt petition has been filed. She also submits that a mention for listing the appeal as unlisted item was made before the division bench in court number 1 of the principal seat. However, the court has directed to list the matter, list the appeal tomorrow. Stop. She submits that in view of the pendency of the appeal and in view of the fact that the same is listed before the division bench tomorrow, 2 days may be granted for complying with the order of this court, subject to what subject to the order passed by the
Lordship, sorry for interruption, but I'm seeking for 2 days for extension of time.
Yes, 2 days time.
Yes, because
Two days.
likely the
2 days.
Lordship 2 days.
2 days time may be extended for compliance of the order. So,
Lordship, in view of the submission of the learned additional advocate general, that in case if they fail in the writ appeal, then they will require 2 days time to complete the process. I have this submission, Lordship. I have
that
one,
will-
That is
one submission.
That
Lordship.
is not my submission, Lordship.
What stops the government, the department, to allow the petitioner to go for conditional admission? If the government succeeds in the writ appeal, okay, we have to go as per the order passed in the appellate court. I'm submitting this because considering the time factor of the journey involved and the process which they are taking, and 22 is not going to be extended. It is all over the country, Lordship. Therefore, the petitioner should be allowed to go for conditional admission
Learned,
with the condition.
Learned Additional AG also submits that the last date of admission for the college in which the MBBS seat for the petitioner has been kept vacant by the government, by the respondents in pursuant to the directions of this court, has not yet been announced.
Yes, Lordship.
So she therefore prays for extension of 2 days. On the other hand, Mr. C.T. Zamir, learned senior counsel appearing for the petitioner, so how you came to know which seat has been reserved?
That was the only seat left. And the director is here, let him say that also. Because why to move around here and there? Director is here, who is aware of all this.
Where is
Right now, it is confidential,
If
Lordship.
another college, let them say also. Let them say, if my submission is
No.
wrong, let them say which is correct.
so? On the other hand, learned Mr. C.T. Zamir, learned counsel, learned senior counsel for the petitioner has submitted that their filing of an appeal would not operate as a stay of the order against which appeal has been preferred. Stop. He also submits that the petitioner has come to know about the seat which has been left, which has been kept vacant from reliable sources, and it would take at least 2 days' time for journey to the said college where, to the said location where the said MBBS college is situated. Stop. I have considered the submissions made by learned counsel for both sides. This court, in the morning session, while passing the order dated, while passing the order, in this case, within bracket, order in this case, was under impression that 18th of August is the last date of admission for MBBS course in the college where the seat has been, where a seat has been kept vacant by the respondent authorities, and therefore the contemners were directed to appear in person. It has already observed in the order passed in morning sessions that from the material available on records, prima facie it appears that there has been non-compliance of this court's order, which would subject both the contemners to the contempt jurisdiction of this court. Stop. However, taking into consideration the fact that the respondents have preferred an appeal and same is listed for motion tomorrow before the
Will be
principal.
listed, Lordship. It is not listed yet.
No, we are believing, but
Yes.
It-
If it
it-
is not listed,
no,
some observation may be made.
no. When she is saying that Chief Justice has allowed it, it has to
Yes,
be,
Lordship.
it will be listed.
After this thing, if it doesn't reach also another problem. Sometimes
we can-
it happen.
What
If
is,
that is the case, we can extend the time, Lordship,
is
to
in
the
motion.
next day. Yes, motion, Lordship, yes.
Motion will certainly.
Sometimes one motion takes the whole day also. We never know. Motion has to be left for
For
that.
motion tomorrow. as well as considering the fact that the petitioner, learned counsel for the petitioner himself has, learned senior counsel for the petitioner has himself has submitted that the last date of admission has been extended from 18th to 22nd of this month.
It's the last date in all the colleges. To bring it.
Stop. This court is allowing the prayer for extension of time to the contemners. Till tomorrow. Stop.
Worship.
Let this matter be listed again on 19th of April at 4 p.m.
Okay, Worship.
The,
Much obliged.
the contemners, whether your presence would be necessary.
Lordship, their presence may be exempted. Lordship, I'll be appearing through VC.
No, I'm ready to exempt your presence because in the original prayer also, additional AG was requested to intimate you for compliance, but you have not complied. Yes, both of you, please say.
Honorable additional AG, she has informed us, and in the late evening we got the copies also. So,
Going for explanation. Explanation we will hear while hearing the contempt petition, which we are not doing. My query is, whatever order court passes tomorrow, will it be required on your part to remain present personally, or is it enough that the government council communicate?
it is enough if government council informs us.
Okay.
Lordship, I have one submission. Lordship has tentatively fixed at 4.
Yes.
Why not we make an attempt at 2?
No,
That is the second.
Lordship, that would be dangerous.
If any
We can
order
take up
is
at
passed, we
4.
will know. And
Because
it's not
I'll
possible
be serving,
it can go to
Lordship,
court.
I'll be serving the
No.
copy of writ appeal
Considering
by
the
letter
submission made by
so he
the-
will know.
Considering the submission made by the director of the department, he said that it will take about 2 days
No,
for completing the process.
we'll take care
In
of
which
it.
case, they are trying to cross the timeline.
We'll take care of that.
Yes, Lordship.
An event stay is not granted.
Yes, Lordship.
Morning also, they were saying that office timing is up to 4 o'clock. Up
No,
to 4 o'clock.
let us
we
not
cannot
go
work.
into, Mr.
Can that be accepted?
Mr. Zamir, let us not go. If stay is granted, your submission will be futile submission.
Yes.
Therefore, reserve it for tomorrow.
I agree. But why not let it be at 2?
No,
So
no,
that they can complete the process.
there is a reason.
Lordship in the earlier order has clearly mentioned
What is this?
how it is. Lightweight.
The contemners, both the contemners have personally assured this court that in the event they fail to get stay from the appellate court, they would be complying with any order, complying with the orders of the court as communicated to them by the additional AG. If Mr. Kure remains present through VC, it's okay. Otherwise,
Lordship.
Imsong may remain present. List accordingly. Accordingly, the personal appearance of both the contemner tomorrow before the court is exempted.
Lordship.
Let this matter be listed again tomorrow at 4 p.m.
Lordship. Much obliged, Lordship.
A copy of this order may be furnished.
You have to wait. This will be uploaded. Let a copy of this order be furnished to the learned additional AG.
For hearing, item number 50.
Mita, type out this order first. Yes. How much time will you take?
My lord, I'll be very brief, my lord.
How brief?
My lord, I'll try my level best. I cannot tell the exact time, but
Who is for the other side?
my lord, may I start, my lord?
Okay, you start.
My lord, the matter pertains to my lord removal of my service, my lord. I was serving as a sepoy armor in the 78th Battalion CRPF Kohima, my lord. Jojoba. My lord may kindly have the removal order at page 24. It starts, my lord, of the writ petition. And the translated part, my lord, 29, my lord. 24, the Hindi portion is there, and the translated portion starts from page 29, my lord.
Yes, what is this? Office.
My lord, this is the office order, my lord, the removal order. May I read, my lord?
This order you are impugning.
My lord, this one, my lord. Order dated 21/5/2019.
Okay.
Yes. My lord, may I read, my lord?
Yes.
My lord, allegations are two, my lord. One is that, my lord, I had entered into second marriage during the subsistence of my first marriage. And the second allegation is that I had given a forged leave certificate for the period, my lord, 29/5/2018 to 27/6/2018 by using the seal of my superior officer. Those are the two main allegations against me. Now, my lord, what had happened in the case is that, my lord, I got married to one lady, namely Vinamrata Dhanesh Kure, my lord, on 19/10/2015, as per Arya Samaj rituals, my lord. Thereafter, my lord, the things didn't work out between us. That is why, my lord, as we didn't have much knowledge about how the marriage is to be dissolved, the proper procedure, we had by our stroke of bad luck, we had just made one marriage cancellation bond, which is not the proper procedure. My lord would have it at page 23A, my lord. 23A, if my lord has for a moment. This is the type copy, my lord. This is the divorce agreement, my lord, which we had entered into. We had married, my lord, on 19/10/2015. And this agreement, my lord, we had entered on 23/10/2015.
Yes.
Yes, ma'am. Now, my lord, what has happened is that the said lady, my lord, Srimati Vinamrata Dhanesh Kure, she had filed one complaint against me. If my lord has page 39 of the affidavit in opposition filed by the respondent authorities, my lord, for a moment. Page 39, my lord. This is the complaint, my lord, to the commandant, CRPF, my lord. May I read, my lord?
Yes.
Complaint against Constable Power Suraj. It is my humble request that I, Vinamrata Kure, who is presently posted in Chhattisgarh Police, Raipur, met Suraj Pawar in 2009 during duty, and since then we started talking, and since that we both used to stay together. Whenever Suraj used to go on leave and came back home after spending leave, even then he used to stay with me in Raipur. We used to have chit chat, and between us, between us. Only after that, he used to report to his company. While we were together, Suraj talked about getting married, and then I also said yes for the marriage. He said, let my elder brother get married, then we will both get married in court. During all such holidays, he used to come and stay with me, and then we both got married in Arya Samaj Mandir on 19/10/2015. My lord, it is an admitted position of fact that both of them got married. Thereafter, my lord, things turned strained, my lord. Things were no more hunky-dory between the both, and she filed this complaint against me, my lord. My lord, relevant portion is on page 20, my lord. The grievances that was against me.
Page number?
40, my lord, sorry. The next page. My lord would have 39, my lord, the end portion for a moment, my lord. Here is the strain, my lord. 39, last portion. Ever since Suraj got married for the second time, my lord, I got married after I had married Vinamata Kure, although I had divorced her, not a proper procedure for divorce, but through that agreement, had got married for the second time. He used to lie to me on leave that I have come on 30 days, 20 days leave, saying this. He used to send me fake news, a fake leave duty certificate from his phone so that I can be sure that for how many days he has come on leave. Similarly, for 2 years, he kept lying to me that he has not married for the second time. He used to talk to me on phone the whole day so that I did not come to know that he had got married. I came to know that Suraj had married for the second time on 16th of June 2018. So, my lord, this was the crux of the complaint, my lord. Now, my lord, later on, my lord, we had formally entered into a divorce also. If my lord kindly has page 51, my lord, of the writ petition, my lord. 51 of the writ petition and 54 is the effective page, my lord. Dissolution of marriage, my lord. Order passed by the Honorable Court below, my lord. Judgment. May I read, my lord?
Yes.
Page 54. Application is allowed. As per dated 19/10/2015, marriage has been dissolved as per Hindu Marriage Act 1955. It got dissolved, my lord. Moreover, my lord, there is a letter by the said lady, the said complainant, stating that she was suffering from certain mental issues when she had filed a complaint. If my lord has page 72 for a moment of the writ petition, my lord, filed by us. May I read, my lord? 72. Yes. This is, my lord, 18/6/2016 letter. This is to the Deputy Inspector General of Police. It is requested that I am Vinamrata Kure on 17th July 2018 at 70th Vahini CRPF Force Headquarters, Jubjuba, Nagaland, had gone to meet Mr. Suraj Pawar. There I was asked about my marriage and our relationship. Then I showed the marriage certificate, but they did not allow me to meet with Suraj Pawar and sent me back after writing a complaint. And again, they called me for giving the statement. On 29th January 2019, I went to 78th Battalion Headquarters and asked to withdraw my complaint, but the investigating officer and commandant Sri Surendra Singh Rana said that this investigation report is now going to the Inspector General of Police, Range Headquarters, Bangalore. We will do the last correspondence with you. Then you, in response, send a letter of withdrawal of complaint. But I did not receive any kind of letter from 70th Bahini. In spite of that, I sent a letter to Shriman Commandant Sir, on which I had requested to withdraw the complaint, but still they take action against the Sepoy / armor Power Suraj. That is me. Sir, both of us have reached a mutual settlement and I want to withdraw the complaint against me. I apologize for the action taken by CRPF office. Now, my lord, there is a marriage registration certificate also at page 74. Later on, the said lady who had made the complaint against me, my lord, at page 74, my lord would have that she is now married with someone else, my lord. So there are two aspects, my lord. The complainant wanted to withdraw. She had the mens rea, the motive to withdraw the complaint, but the authority.
No, what is the law which governs
Yes, my
your
lord.
service condition?
My lord, my service condition is governed by the CRPF Act, the CRPF rules, and the CCS conduct rules.
What are the provisions there?
There, my lord, section 11(1) of the CRPF Act. If I may kindly hand over the copy of the Act, my lord.
Yes.
My lord would kindly have section 11, my lord. 11 for a moment. My lord has the Act, my lord. Section 11, my lord.
Yes.
Yes. Minor punishments. The commandant or any other authority or officer, as may be prescribed, in lieu of or in addition to suspension or dismissal, any one or more of the following punishment to any member of the force whom he considered to be guilty of disobedience, neglect of duty, or reminiscences in discharge of any duty. Following may be imposed: reduction in rank, fine of any amount not exceeding 1 month's pay and allowance, confinement to quarters. Then, my lord, confinement in the quarter guard for not more than 28 days with or without punishment, drill or extra guard, fatigue or other duty, removal from office of distinction or special emolument in the force. That was imposed against me, my lord. Section 1, subsection 1, subclause E. Removal, my lord. I was removed from my service.
What is this office of distinction?
My lord, office of distinction, my lord, the rules have it, my lord.
Why you are saying that he will be punished under?
My lord, because this article was imposed against us, my lord. My lord may kindly have page, my lord. 20,
Are you not punished, penalized under section 12, dismissal from service?
Yes, my lord. 12 also, and 27 of the CRPF rules is also there, my lord.
No, but you are submitting that under, you are punished under
Section 11, my lord.
11E.
Yes, my
Is
lord.
it section 11E, 1E or
My-
under section 12?
My lord, because in their impugned order, my lord would have page 62 of the affidavit in opposition which they have filed, my lord, the respondents. There also they have categorically stated it is section 11(1).
Oh, in the impugned order they have mentioned.
Yes, my lord. May I kindly read 62, my lord? It is there
Okay.
impugned order.
Okay, please read that line.
Yes, my lord. That the force number so and so, Constable Armor Power Suraj Prakash, while serving in 78th Battalion CRPF, has committed a serious offense under section 11(1) of the CRPF Act 1949 in his capacity as a member of the force, in that he married Srimati Pooja Suraj Pawar, his second marriage, while his first wife Srimati Vinamrata Kure is alive, which is against Rule 15 of the CRPF Rules 1955. This act is punishable offense under Rule 27 of the CRPF Rules 1955. That rules also I have, my lord. Dismissal, if I may kindly hand over, my lord. That is also there.
What is office of distinction?
My lord, office of distinction, my lord, I plead ignorance, my lord. So also, my lord, I plead ignorance, my lord. I apologize. My lord, may I kindly proceed?
Yes.
My lord, my basic case is that, my lord, removal, my lord, is a harsh form of punishment, my lord. The Honorable High Court, in various judgments, my lord, has observed the same, my lord. they have observed with regard to, my lord, dismissal, my lord, that dismissal is a harsh form of punishment. Any other form of punishment may be given, any other minor penalty or anything, my lord. Because, my lord, dismissing or removing someone from service, my
No,
lord.
whether these two are same phrase.
No, my lord.
Removal from office of distinction
Yes.
is the penalty prescribed under 11E, 1E.
No, my lord.
And dismissal is the penalty prescribed in 12(2).
Yes, my lord. My lord, I have been removed, not dismissed. Now, my lord, in dismissal, one is barred from getting any
Further.
removal, one can again apply.
Okay.
But, my lord, since there is a scar now in my profile, my lord, I will not get any further employment, my lord. That is a settled position right now with me. Because wherever I go, government or public, government or private, I will not be approved, my lord, because of this scar. Now, and my lord, second thing is that I have a family to sustain, my lord. My lord, I would like to draw parity of one order passed by the Honorable High Court, my lord. Amal Kumar Borwa, if I may kindly hand over, my lord.
Yes.
Yes, my lord, in Amal Kumar Borwa, my lord, what had happened is that, my lord, in a similar situation, my lord, the petitioner had got married, my lord. 2 marriages, my lord, same, bigamous marriages. But, my lord, the Honorable Court had observed that, my lord, imposing a punishment of removal or dismissal is extreme form of punishment, my lord.
Here he was dismissed.
Here he was dismissed, my lord. And, my lord, there, my lord, Profulla Kolita was also has also been observed, my lord, at paragraph number 8 and paragraph number 10, my lord. 8 of the I've marked it, my lord, where it is said that bigamous marriage should not invite extreme punishment such as dismissal.
Where read that.
Paragraph 8, my lord. My lord, I just had one copy, my lord. I marked the copy, my lord. Paragraph 8 it starts, my lord. Paragraph 8 of the said order.
Albert, give it to him. Read out and highlight the portion which you are.
Yes.
Lordship, there are 2 charges. Yes, sir. One is bigamy and one is
Showing false
documents, manufactured documents. So we may continue this for already 4:30. We can continue tomorrow.
No. We will finish it. You finish within 2 minutes.
My lord, I'll be brief. I'll be very brief, my lord. Then, my lord, this is the spirit of my submissions, my lord. That here, my lord, it is dismissal, but I am saying removal is also an extreme form of punishment. Then, my lord, there is a division bench judgment, my lord. My lord, it is a very recent judgment, and that is holding the field. My lord, Pranab Nath, my lord. My lord, in fact, my lord, I'll just hand over the judgment, my lord. This is holding the field. I am saying this because, my lord, the respondent authorities, they have in fact filed an appeal against this in the Supreme Court. But in the Supreme Court also, notice has only been issued in this case. No stay has been granted in Pranab Nath. Pranab Nath also says that.
Which para you are relying on?
Pranab Nath, my lord, would have the pink flag, my lord, would kindly have. My lord would kindly have paragraph 10, my lord, if I may read. 9, my lord, sorry. 9, it starts, my lord. Pranab Nath.
Yes.
Dismissal is the most extreme form of punishment.
But these are judgments pertaining to dismissal.
Yes,
You yourself submitted that dismissal and removal are different
they are
punishments.
distinct, my lord. But, my lord, I am drawing the parity on the ground that same both precludes the person from getting a job, my lord. Although there is no embargo upon a person getting a removal from applying somewhere, but, my lord, that scar continues, that stigma continues, my lord. That cannot be done away with, my lord.
Okay, please read.
Yes, my lord. My lord would have paragraph 9. Dismissal is the most extreme form of punishment which can be imposed upon a government employee, which has the effect of not only cutting off the source of income, thus depriving him and his dependents of the means of sustenance. Apart from it, he will not be eligible for re-employment in public sector. Thus, the civil consequences it entails are of extreme nature, which in our opinion should not be ordinarily invoked, unless the misconduct is of such nature that there is no other option but to impose such a punishment. There can be various other serious misconducts which this most severe form of punishment can be imposed. In the present case, in our opinion, though this act of conducting of second marriage can be said to be an act of indiscipline, inasmuch as contracting a second marriage during the subsistence of first marriage was in violation of rules. Yet, it cannot be said that it is one of the most heinous forms of misconducts for which he must be necessarily visited with the punishment of dismissal. Records also do not indicate of any serious physical violence perpetrated upon the first wife or the daughter of the writ petitioner or any other act of cruelty. That is my point, my lord. Again, my lord would have paragraph 11, my lord, beneath my lord. Under the circumstances and taking a holistic view of the entire circumstances as reflected in the records, this court, without condoning the said act of misconduct, is of the view that imposing the punishment of dismissal to the writ petitioner would cause serious economic hardship, not only to the petitioner himself, but also to his first wife and his daughter, and also to other women. The punishment of dismissal imposed on the writ petitioner will deprive the family members of financial support and also may drive them to penury. In our opinion, devastation which may be caused, more particularly the financial hardships which may be caused by the penalty imposed to the family members, can be one of the parameters for judging as to whether penalty imposed is disproportionate or shocking. In our view, keeping in mind the misconduct proved, if a lesser penalty could have been also imposed for the said misconduct, the authorities must examine the impact which will have not only to the employee concerned but also to all of his family members who are entirely dependent on him before taking the severest and ultimate form of punishment under these rules. Here, my lord, the honorable court, honorable single judge had also set aside the order and this was upheld thereafter at paragraph 12 that is written. My lord, in the first order that I had given, my lord, Amol Kumar Borwa, 2006 GLT 569, there, my lord, I would like to draw a parity with my case, my lord. Because there also, my lord, in my case, the complainant, she has given a withdrawal petition.
Okay, facts resemble, but the punishment is different.
Punishment is different, my lord. But again, there is an embargo, my lord. Again, I am handicapped, my lord. I will not get re-employment anywhere. My lord, I know, my lord, there is a difference. It is an admitted position. I am not denying it. I have showered light upon it. I am admitting to it, my lord. But the fact remains, my lord, I will not get employed anywhere. I have a minor child, my lord, a wife to maintain.
Okay.
And my lord, a few more orders I would, if it pleases my lord, Trilok Singh Rawat, that order, my lord, I would like to hand over, my lord.
No, in respect of what proposition? Same.
Same, my lord. But this is also dismissal, not removal.
Then keep it with yourself. You need not to cite more numbers of cases on a single point.
My lord.
Yes, Mr. Imsom. Yes.
Last
Yes.
submission.
Will you be here tomorrow?
No, my lord, I have a few matters in principle say. That is why.
Then, okay, conclude.
Yes. My lord, my last leg of submission would be that, my lord, the withdrawal complaint that the lady Srimati Vinamata Kure had given at page 70 of the
Yes,
petition.
facts are.
No, my lord, I am saying in that it is said that she wanted to withdraw her complaint, but the authority said that it is under process and now you cannot. Ever since that application has been kept in a limbo, that has not been given a due consideration. Be that as it may, my lord, I might have committed the said act, but when the complainant wanted to withdraw it, the authority should have also shown their bona fides of allowing her to withdraw. Maybe they have proved the charges against me in their impugned order.
Under
That-
what,
that
pro-
is-
under what provision?
My lord,
What are the provisions?
well, non-consideration of the representation of the withdrawal complaint, my lord. That is who is the complainant. If the complainant wants to withdraw,
Under the scheme of CRPF Act,
no,
is
my
there
lord.
any provision?
That my lord is that
Not there.
that I have not
Okay.
found. I have not come.
Your
across.
submission is considering the facts that the complainant has condoned the acts done by the petitioner. The withdrawal should have been allowed.
Should have been allowed.
Okay. Okay. Yes, Mr. Yangarvati. You take 5 minutes.
No, sure, I'll just read out the brief history in all the facts and things I have
No,
in my written statement.
Facts are now familiar to me. Why are you opposing the?
Because without intimating to the department, he has married twice. Already after
Okay,
the
that
marriage.
is one offense.
And also, Lordship, I'm preparing a fact certificate. Lordship may come to. Page 4, Lordship, Article 2. Page 4.
Yes. He prepared fake
Yes,
leaves.
Lordship. Article 2, page 4 of the my affidavit, Lordship.
Yes.
Article 2, Lordship recorded. Article 2.
Yes.
That said for so and so, so and so has committed a heinous offense under section 11(1) of the Civil Act 1949 in his capacity as a member of the force, whereby he prepared a fact leave duty certificate for 30 days and leave on date 28/5/2018, and he put his signature on the seal of the commandant 1978, which is a punishable rule under Rule 27 of the Civil Rule 1955, which was attributed by him after that.
Okay.
That has been admitted that he had prepared the fact certificate.
But why have you gone for the
Pardon?
extreme punishment?
This is an extreme punishment, Lordship. Making fact certificate of the commandant, Lordship, is commanding officer. That is an heinous act, Lordship.
I'm denying it, my lord. Page 7 of my affidavit in reply, paragraph number 8. I'm categorically denying it. I had no role whatsoever. Page 7 of affidavit in reply filed by me. Para 8.
Okay. Mr. Imsong, you are also there?
No.
You're still waiting.
My lord, with folded hands, my lord, I would like to make one last submission, my lord.
Yes.
My lord, perhaps the charges which have been alleged against me, my lord, they found the authorities have come to a conclusion that they are proved against me. Be that as it may, my lord. Today, my lord, I have to sustain a family, my lord.
No, but these submissions may not be applicable in case of a member of armed forces.
My lord, there are other forms of punishment as well.
You are required to be more disciplined.
Yes, my lord. That is true, my lord. But at the end of the day, my lord, a humanitarian touch has also to be given, my lord. Now, because of my mistake or my removal, my family is also suffering because they are dependent on me. I have a minor child, my lord.
Okay, that you have submitted. Okay, heard, Mr.
Your name?
Which?
My lord, my name is not reflected in the cause list, but I have submitted vakalat, but I have filed vakalatnama.
Heard, Mr. I forgot your name.
No problem. PR Sharma.
I heard Mr. P.R. Sharma, London, counsel for the petitioner. Also heard Mr. Yangarvati, London, Central Government Council. Hearing concluded, judgment reserved.
I am deeply obliged.
for hearing item number 51.
You have 10 minutes.
Please, Lordship.
Or should we take it?
Lordship, here there's urgency. Is that
There
Lordship?
is an interim.
No, Lordship, that is why I'm pressing Lordship this matter. And since while the matter was pending, they have filed their affidavit in opposition, so I did not press on the interim since it was fixed for final hearing. However, since last week, due to paucity of time, we cannot take up the matter. So, Lordship, my submission is very small, Lordship. In fact, the case is not. It's not. The matter is very small, Lordship. It's big.
Will you be able to complete within 10 minutes?
Lordship.
How much time will you take, Mr.?
Lordship, I have mentioned in my affidavit of opposition.
Okay,
Reform, that's all.
we start for, if it requires more time, we'll take it tomorrow, but keep
Lordship.
it parted.
Lordship, I'll try to finish it, Lordship.
Yes.
So, Lordship, here the petitioners are seeking for regularization of their services, Lordship. The petitioner number one is the General Secretary of the Association, Lordship, and they are pursuing the matter for petitioner number 2, 3, and 4, Lordship. So, Lordship, here the petitioner number 2, 3, and 4, petitioner number 2 and 3 have been serving under the department for more than 24 years, Lordship. And petitioner number 4 is serving for more than 14 years, Lordship. And Lordship, here the other more ground is that, Lordship, the similarly situated person who was also appointed in the similar nature of appointment was also regularized, has been regularized, Lordship.
What is the office memorandum or the rules?
Lordship, OM was to do with the reservation of the post in the interim, Lordship. To reserve the 50% of the post as per the OM, 50% should be direct recruitment and 50 should be for the promotion, Lordship. So that is why we have annexed this. But since in the approval, administrative approval, Lordship, the one which is under challenge, there they have issued, they have given the approval for recruitment of 6 posts, Lordship. In fact, Lordship, there are 8 posts, Lordship. Now the vacancies, there is 8. The sanction is 10, but now the vacancy is 8 posts, Lordship. So we are seeking for in this OM that is for reservation of the 3 posts till the disposal of the. In fact, we are seeking only for 3 posts, Lordship, to reserve till the disposal of this case, Lordship. That is why we have annexed the OM, Lordship. However, with regard to regularization, Lordship, they have been serving for more than 24 years and also 14 years, Lordship.
Which law governs regularization?
Lordship, with regard to regularization, the law is settled that after in the apex court as well as high court is held in the category of decisions that after utilizing the service of the employees for more than a decade, Lordship, and if not regularizing, it amounts to exploitation of the temporary employees, Lordship. In fact, I have many citations, Lordship. In fact, and Lordship, in the
what is the policy of the government in this?
policy, Lordship, there since in the work charge, Lordship, because the state they're under contract basis, Lordship. So in a contract, normally they when the vacancies arise, Lordship, after the law is set, Lordship, in this OM it should be when the post is advertised, it should be 50% for reservation and 50 for the promotion, Lordship. So here in the Lordship, when it comes to regularization, the work charge, Lordship, the 2005 OM, Lordship, here they have said those who have completed 10 years in the OM, 2004 OM, Lordship. And in the 2018 OM, but both are still suffice, Lordship. Even the 2004 is still in.
Where is that 2004 OM?
Lordship, the 2004 OM.
No.
Lordship.
Apart from the submissions
Lordship.
that you have worked for 24 and 28 years.
Yes.
Are you relying on some government?
No, Lordship. That I'm relying on a parity, Lordship, on the similarly situated person who have been whose service has been regularized, Lordship. I'm not, this OM is purely for reservation, Lordship, for 50-50, Lordship. Otherwise, for the regularization, Lordship, I'm relying on the principles of law that has been settled by
Which OM is for? Which OM you are referring to?
Lordship, my apologies,
No,
Lordship,
no.
there is one,
This reservation
yes,
which
it's at the
provides,
Annexion 19, page 49, Lordship. That is at Roman number 3, Lordship. Page 49, Annexion 19, Lordship. That is for reservation of the vacancies for recruitment and recruitment process, Lordship.
no, this is the policy and scheme for regularization
Yes, Lordship,
of work charge employee.
Lordship.
So 2004 policy and
Yes,
one
Lordship.
2015 policy is also there.
Yes, Lordship, but that I have not annexed, Lordship. Because in that OM, Lordship, they have though it has not been superseded, this OM has not been superseded, but in that OM they have when it comes to work charge, Lordship, they should complete the 30 years of age. 30 years, and in my case, Lordship, we have not reached the age of 30. However, Lordship, in some of the state respondent, in fact, normally when it comes to employees of temporary ad hoc, they are taken in the same part. That is why we have annexed this OM. Otherwise,
Employees ad hoc.
yes,
as
temporary contract.
Contract are treated at par with work charge
Work
employees.
charge employees, Lordship.
So OM of 2004 and 2015 are applicable to you also.
Lordship, however, Lordship, in our case, Lordship, because there is a vacancy, Lordship. There is a vacancy, and us being the senior most in the department now, Lordship. And in fact, the similarly situated who were appointed on the similar ground, on the similar nature, there have been he has been regularized. That I have also annexed in my next year, Lordship. So this, in fact, Lordship, this OM was only to was best for.
No,
Yes,
it is
Lordship.
not only for reservation.
Lordship.
It also lays down criteria for government policy for regularization.
Yes, Lordship. Lordship, here, in fact, in the Roman number 7, Lordship, that is page 50, Lordship. Here they have stated, they have not mentioned in fact, in the 2004, they have not mentioned the years of service. In fact, it has mentioned that merit, Lordship.
Yes, in
Regularized
2004,
work
minimum
charge.
service is
Yes.
not been mentioned.
Yes, Lordship. They have not mentioned, but it is the continuous work, their continuous.
So where is 2015 regulation?
Lordship.
In the affidavit in opposition.
No, Lordship. In fact, their only contention is that that while our representation was in process, we have filed, they are stating that we have filed this application, Lordship. That is their only contention in the affidavit.
Is it? Okay.
Yes.
Yes. So your contention is that you are senior most.
Yes, Lordship. And they have been utilized our service for more than 20 years.
But you do not conform to the requirement of 30 years of regular
No, Lordship. In
service.
fact, in the yes, Lordship, in the Umadevi case, Lordship, they have it is stated that the thing after the employees, those who have served for 10 years, they are.
That was one time.
Yes, one time, Lordship. That I agree, Lordship. So, however, Lordship, in the latest in the apex court decisions, it is held that Umadevi should not be taken as a shield to justify the exploitation engagement, Lordship. It's very clear in the judgment, like not to exploit the employees, Lordship. And here there is a vacancy, Lordship. It's a clear vacancy, Lordship.
Yes, Mr. Imsam.
Lordship, I have a very limited ground to say. So I am confined on my affidavit in opposition, paragraph 4. Affidavit in opposition file on 11 occurs this month. Paragraph 4. Because the government has already establishment of the Department Recruitment Board is in the process for completing the necessary formality for recruitment. So my stand is confined only in the paragraph number 4. So in order to save time, and even if I keep the submission also, that will be a repetition only. So my humble submission before Lordship is sufficient time will be granted to the respondent for completing all those process.
Okay.
So that is my submission.
Okay, I'll go through And
Lordship, if I may allow to produce some other additional judgment also.
yes, mark the paragraph number.
Yes, Lordship, I have marked it, Lordship.
And you also mentioned that it is by the petitioner.
Lordship, my apologies, I have not, I'll write it now.
Okay, you can give it because respondent has not submitted any judgment. No need to write. Heard Miss Mika H.I., learned counsel for the petitioner. Also heard Mr. Imti Imsong, learned additional advocate general, appearing for the state respondents. The hearing concluded, judgment reserved.
Much obliged, Lordship.